Hey, please. Item number 27, my lord.
Item number
Has got the
27.
20.
Petitioner has got the relief. Okay. Standing counsel first.
I have informed them.
Okay, Mr. A.H.M.R. Chaudhary, learned counsel for the petitioner, has submitted on instruction. Since the petitioner has got the relief during the pendency of the writ petition, the petition doesn't want to pursue the writ petition any further. Full stop. In view of, he has further submitted that the issue has been informed to the learned counsel for the learned standing counsel for his department. Full stop. In view of the above submission made by Mr. Chaudhary, learned counsel for the petitioner, the writ petition is dismissed on withdrawal.
Other pair file. 12 of them.
Okay.
The concept of this respondent project, I recommend on item number 29, 32,
29.
29, 32, 33,
Hmm.
34, 57, and 58. Well, let's say they have filed affidavit. Therefore, accommodation also file with
How much time you need?
2 weeks,
Huh?
3 weeks.
Few weeks.
Lordship.
Mr. A. Deca, learned counsel for the petitioner, has sought for and is granted 3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the state respondents. First of Ms. Eudas, petitioner senior government advocate for the state respondents, is present. Release the case on so and so. Same date. Same date. 57 and 58.
29, 32, 33, 34. Then in supplementary list lordship 57 and 58. I have one more prayer lordship for listing of 2 writ petition in the admission column.
Give it to the
Lastly.
court, boss.
Outline.
My lord, item number 54, my lord. It's a supplementary item, motion item, my lord.
Yes.
There have been subsequent developments. We'll pray for liberty to withdraw the
Yes.
petition, my lord, with the liberty to file afresh.
Okay. Mr. M. Sharma, learned counsel for the petition, has submitted that as their subsequent developments which have a bearing in that case, the petitioner wants to withdraw the writ petition with the liberty to file afresh.
My lord, I'm grateful.
First of, in view of the above submission made by so and so, learned counsel for the petition, the writ petition is dismissed on withdrawal, with the liberty, as prayed for.
My lord, if I may be permitted to also pray for listing of a matter subject to this. lordship's
Okay, how many?
One, my lord, one. I'm grateful, my lord.
May I please? I beg to mention item 26, my lord. In this case, my lord, petitioner expired.
Huh?
Item
26?
26
Petition expired.
expired.
Oh. Mr. B. Purakasto, learned counsel for the petitioner, has submitted that learned counsel, who is to represent the petitioner, has submitted that the petitioner has expired in the meantime. First of, Eudas. Okay. Eudas, additional senior government advocate for the state respondents, and Mr. M. Goswami, standing counsel for the state department, are present. First of, in view of the above submission made by Mr. Purakasto, learned counsel for the petitioner, the petition is dismissed.
Wait, please, ma'am. Item number 11, my lord, filed an additional affidavit yesterday, my lord.
Yeah, please, your lord. I beg to mention item number 39, lordship, with consent of the respondent.
39.
39.
Yes.
Matter may be adjourned for the day. Some part.
Adjourn for the?
I am for the petitioner, lord.
Adjourn for the day.
Yeah, for the day, lord.
I am for the private respondent.
Huh.
We will be filing the wakalatnama and other instruction on the.
Okay. Mr. A.B.T. Hogg, learned counsel for the petitioners, has sought an adjournment first of, with the consent of the learned counsel for the official respondents. First of, Mr.
T. Majumdar.
T. Majumdar, learned counsel, has submitted that he has entered on behalf, appearance on behalf of the private respondents, and the wakalatnama will be filed shortly. First of, how much time you need, Mr.
Next weekend.
Okay, as sought for by Mr. Hawk, list the case after a week on a date to fix by the office.
May it please your lordship. My lord, this writ petition is filed on 7th February, my lord, and I am praying for listing on 13th February, my lord. Friday.
New writ petition.
New writ petition, my lord.
Okay, 13th is what? Okay,
May I please your lordship? Lordship, I beg to mention for item number 20, item number 5. Lordship may kindly
Item number
accommodate
5.
for on 2 days. Next, lordship may kindly fix the matter next week, man. Any day next week.
okay, on the way of Mr.
AJ Tamuli, my lord.
A.J. Tamil Learned Counsel for the petitioner, list the case on Wednesday, next Wednesday.
Obliged. ma'am.
Your Lordship, there's a similar matter, item number 28. Lordship, may kindly tag along both the matters together. Both the cases have the same subject matter. Item number 28.
Okay, your name, please.
S. Sharma.
On the request of Sancho, list the case on same Wednesday.
Obliged.
Lordship, I beg to mention an unlisted matter, Lordship. The state of urgency is that trucks are being detained at the rail rack.
Hmm?
Trucks, coal trucks are detained at the rail rack, and there were similar writ petitions where order was passed. And interim was also granted. And on Friday, there was a judgment on the series matter. But so far, we are still being detained, and we are being charged on daily basis.
Tomorrow.
Tomorrow, Lordship. Much obliged.
May I please your lordship, I beg to mention item number 6. Senior counsel Mr. Pijaswika is out of station. Matter may adjourn.
Okay. On the prayer of Mr.
R.K. Mohanto.
R.K. Mohanto Learned Counsel for the petitioner. When do you want?
Lordship, after 20,
After
20,
23.
obliged.
Lordship, I'd like to mention 3 new matters, WBC matters. All 3 of them relates to tender matter only. So kindly, Lordship can,
When do you want?
Lordship, 13th will be 13th of
13th.
February.
13. Okay.
May it please your lordship, I beg to mention the listing of a IA, your lordship, in a writ petition.
Hmm.
So the state of urgency is that in the last order, this honorable court has ordered me to operate, or respondent bank to operate the bank account which was freezed by the bank account, your respondent bank, your lordship. But the bank has not complied with such order.
Okay, next week. Give it it.
Much of
May I please your lordship? May I pray for listing one urgent matter? Urgency is because of the day after tomorrow I'll be out. That is why matter is pertaining to tender matter. This interim order is operating. That is why we cannot finalize this one. Our tender is also that earlier tender is going to be regarding this vehicles matter.
Interim order is operating.
Right. That is why, may I
When is
pray
the
for-
date fixed?
That was the last
In the
one.
normal course?
No, it was on 7/1 itself after 3 weeks.
Hmm.
But it has not been listed. That is why, my lord, only this is my personal inconvenience. I am praying this.
When you are? Next
tomorrow.
week? Next
So-
week?
But next week, I'll be not there. That is why tomorrow, if it is possible,
Where?
tomorrow,
No, tomorrow no. Tomorrow and day after tomorrow.
very small matter otherwise.
No, next week, next week.
That
You have
Monday,
inconvenience next week also.
my lord.
You have inconvenience in the next week.
No, here, what happened?
No, is there any IA?
No, not I. Only repetition. Because they are due
You have
to-
filed your counter.
Yes, everything is over. Pleading is over.
Okay. Wednesday, next Wednesday.
Monday?
Next Wednesday.
Monday. Next one.
Monday. there's some
No, no, it's a very small
some
matter.
difficulty in the sense that this court is not sitting in the first half.
Achha.
And the second bench is also not sitting.
That is small matter. Tuesday, my lord.
It's very difficult.
Tuesday.
Wednesday?
Obliged.
Daily list for motion, item 1.
May I please your lordship? My lord, this case relates to the non-payment of higher charge, my lord, not contractual bill, my. And in that, my lord,
It is already fixed on 16 to, what is the
My lord.
hurry?
I am, my lord,
By order you have listed this?
yes, my lord, 3 matter, my lord, in 2 cases I have filed affidavit, and this, my lord, affidavit, already acknowledgement is there, my.
Huh.
Acknowledgement is already there, Lordship, can be turned to page 16, 17, my lord. My junior brother, my lord, could not place the matter before the honorable court, my lord, as I was out of station. It is already there, my lord. And his case relates to only higher charge, my lord. Not as like other contractual bill. And it is there, my lord, serial number 6. The higher charge shall be paid to the submission of the bill, and bill has already been submitted.
Okay, we'll keep it open. Heard Mr. J. Borvian, learned counsel for the petitioner. And Ms. Udas, learned additional senior government advocate.
Or 1, 3,
He
4.
could have waited till 16th for all the respondents. You were there,
2C is appearing, madam.
huh?
For 2, BTC.
Okay, Miss Anne Sodhuri, learned standing counsel BTC for the respondent number 2. Baki Udas. So stop. Para. Mr. Borvian, learned counsel for the petitioner has submitted that the vehicles of the petitioner were hired pursuant to orders issued by the respondent number Where is the second page? Say, for example, page 15.
1-5.
Ah,
This is the only page.
no, at the bottom,
Bottom, my lord.
continued page 2.
No, my lord, it is supplied only this one.
How can it be incomplete? Cannot be, there is no
Same,
signature.
All the pages are same, my lord.
No, there is no signature at the end. It cannot be.
Signature is there, my lord.
Mr. Borvia, don't say to this court like that.
My lord, whatever supplied, my lord, in all the pages, my lord. There should have been one more page.
No, there must be.
Yes, my lord. In
Not
other
should have
pages
been.
there.
There must be. Why you have annexed it partially? It cannot be like that. All the orders.
Yes.
Look there.
Either you annex it fully or pursuant to orders passed. Equivalent hired and released. Were hired pursuant to, this is the order of release or what?
No, my lord. Requisition period to period.
Pursuant to, were hired pursuant to orders passed by the respondent authorities. Pursuant to orders passed by the office of the deputy commissioner for the purpose of maintaining law and order duties, and the same are annexed at Annex 1 to the requisition. First of para issue notice, Ms. Das, Land Additional Senior Government Advocate, has submitted that there is no admissibility statement from the head of the department. Post of issue notice returnable on so and so, as Miss Das so and so, and Miss Chaudhary has appeared accepted. No formal notice, extra copies, as there is no annexation, in view of non-annexation of the admissibility statement from the head of the department, the matter of the issue of maintainability the writ petition is kept open for consideration.
18-3. Item 2.
Yeah, my lord, we have filed affidavit, my lord, with enclosing all the document. Lordship kindly turn to, it is there, my lord. Second page, Lordship was making query, my lord. It is there. Page, starting from page 42, Lordship will see of my affidavit. That's it.
An extra 5 করে দিব আগৰটোত an extra 1 আছিল ন you does
For all.
for all same
Item 3.
3 also, my lord, we have filed affidavit.
which an extra
For the. That is the last. Yes, ma'am.
an extra 5 Miss Das all
Yes.
for all
All.
for all same
Item number 4.
Public.
Now that blacklisting matter,
that
the two matters are there, my lord. Another is
we're thinking of disposing it off yes the other one today
36. Both may be.
No, this at least notice should go and in view of this Nestor Pharmaceutical, it should be kept in abeyance. This is the position now.
Yes, my lord.
There is no product development.
No.
Yes.
Position as it stands today, that is being held
Yes, my lord.
in paragraph
32.
And no
42.
42.
and no termination of the
Red one.
red contact.
Okay.
Cancellation.
The other one, Mr. Sahiwala,
Yes.
I'll put it tomorrow. I'll have lesser time to dispose it off. Right? The other one. This one I am issuing notice.
Yes, my lord.
Heard Mr. G.N. Sahiwala, learned counsel for the petitioner. Senior counsel is stated by Mr. M. Sahiwala, learned counsel for the petitioner, and Mr. D.P. Bora, learned standing counsel, health and family welfare department for all the respondents. Full stop. The petitioner has approached this court by the Senate petition to assail a farm debarment notice dated 17/11/2025. Annexer?
Annexer, my lord, 16, Roman 16, page 139.
Within bracket, Annexer Roman 16. Issued by the respondent number
3.
three, whereby the petitioner company has been blacklisted and debarred, page 140, from participating in any tender for 3 years from
That of issuing the letter.
17/11/2025. In terms of clause number 5, subclause capital H, point number Roman 2.
Yes.
And Roman end, point number 3. And subclause M for alleged default in supply of 4 number of essential anti-malarial drugs against 6 number of purchase orders within bracket POs as mentioned in Annexer 1, Pair 2. Full stop. Para Mr. Sahola, Senior Counsel appearing for the petitioner, has submitted that the matter of supply and delivery of the essential items, stroke drugs, within bracket drugs, are governed for empaneled vendors are governed by terms and conditions
Direct contract.
incorporated in the bidding document and the contract agreement, framework agreement. More particularly, clause 5 within bracket of a capital H clause 1, capital H, first up. He has submitted that in case the empaneled, in case any empaneled vendor like the petitioner company fails to supply or in case of in case of non-supply or incomplete supply less than 90% of the total ordered quantity by any empaneled vendor within the agreed delivery period, then the concerned rate contract had to be cancelled. And in case the rate contract in respect of 3 or more items, drugs, are cancelled, then only such an empaneled vendor can be visited with the penalty of firm debarment. First off, in the case in hand, there is no cancellation of the rate contract, and therefore, the debarment, the action, the penalty of debarment and blacklisting under clause 5H within bracket Roman 2 could not have been imposed. First off, he has referred to a judgment dated judgment and order dated 11/2/2025 passed by a coordinated bench in WPC number 6735/2025 in bracket Nestor Pharmaceuticals Limited and another versus State of Assam and 5 others, wherein it has been observed that without there being a product debarment upon cancellation of the rate contract for the items, the question of going into firm debarment is not envisaged on a conjoined reading of clause 5H within bracket 1 and clause 5H within bracket 2 of the bidding document. So, para, Mr. Bora has contended that there was consistent failure and non-supply on the part of the petitioner to deliver the items stroke drugs within bracket drugs during the stipulated delivery period indicated in the purchase orders. Full stop. So there was no cancellation or rate contract, comma, the facts and circumstances have clearly called for debarment and clearly called for an action for debarment and blacklisting. So stop. Issue notice returnable short dated. You file your affidavit.
Yes, my lord.
Short dated
6-3.
6-3. As Mr. Bora has appeared so and so. The council for the parties are heard also on the interim prayer post. It is no doubt that an action of debarment and blacklisting visits a person stroke entity with serious civil consequences. Post in the having gone through the judgment in Nestor Pharmaceutical Supra on the in Nestor Pharmaceutical Supra, a coordinated bench has already observed that before an action under section 5H2 of the bidding document, comma, there had to be product debarment for at least 3 items as per clause 5H1 of the bidding document. Full stop. As the petitioner, as a rate contract in respect of 4 items stroke drugs, comma, as indicated in the statement annexer A to the impugned farm debarment notice dated 17/11/2025. Do not do not go to indicate that the action of farm debarment stroke blacklisting is preceded by product debarment, any product debarment and cancellation of the rate contracts. Post of the position as it stands today in view of the judgment in Nestor Pharmaceutical Limited Supra, comma, this court is of the considered view that the petitioner has been able to made out a prima facie case for interim relief. Post of accordingly, comma, it is ordered in the interim that the impugned farm debarment notice dated 17/11/2025 and XR so and so shall remain in abeyance till the return implement.
36 tomorrow, my lord.
Tomorrow, GN Sahewala, M Sahewala, EP Bora, tomorrow.
7.
Passover timing.
Passover timings.
Yes, sir. This on the outside. That position.
Oh, we can issue notice. There is no. We can issue notice. Only that to that extent. Remission or refixation. Refixation of the revenue.
But because my lord is dry up. Dry up, my lord.
Or your representation is pending.
My lord, I'm acting. Yes.
Can it be?
Representation is pending. When two representation pending, my lord.
Can it be disposed of or?
Or that can be, my lord, yes, with the time frame, my lord. That
Because
can be-
we cannot take the decision
Yes, yes.
otherwise.
Because, because there is a power, government has power. Because I have as per the rule, my lord.
This is AMDC or fishery?
Fishery
Department.
Development Corporation. Assam Fishery
AMDC. Yes, he has power or not?
Yes. Role of remission. Power means only if it is in NIT, lordship. No, my lord. It is in NIT. Lordship, we will provide.
No, that rule will not be applicable. Will not be.
That rule is not able to damage, yes.
They are corporation.
Let them, my lord, no situation, your lordship. We sometimes in some cases we accept lordship. So if it is.
So, any report?
Yes, we used to take report from the reporting commission.
Who is there? Is there any report? Where is that?
The report is page 87. Page
87. So take that on board, take that report into consideration.
Yes, lordship.
Right.
Yes.
And pass a speaking order.
Lordship.
That will do.
Yes, lordship. My lord, that will do, my lord. I will not get more than that, my lord.
No. Third, Mr. T.J. Mohanto. Learned Senior Counsel, estate by Mr. T. Gogoi. Learned Counsel for the petitioner. Mr. P. Sharma. Miss, you for all?
All.
Mr. P. Sharma, except
1,
four.
2, 3.
Okay. Mr. P. Sharma, Learned Standing Counsel, Fishery Department and AFDC. For the respondent number 1, 2, and 3. And Miss Udas, Learned Additional Senior Government Advocate for the respondent number 4 and 5. Full stop. Responding to a tender notice dated 14/3/2022, inviting bids for settlement of a fishery named Kumotia Group Fishery, Dhemaji, for a period of 7 years.
7 years.
The petitioner submitted his bid, and upon evaluation, he emerged as the valid bidder for settlement, full stop, by an order dated 5/7/2022. Fishery for short. Where is that order?
My lord.
Settlement order.
Settlement order, my lord. Final order of settlement, annexed page 72.
By an order dated 5/7/2022. Issued under the hand of the respondent number 2. The fishery has been settled in favor of the petitioner for a period of 7 years from the financial year 2023-2022-2023 to the financial year 2028-2029, that is up to 31/3/2029. Full stop. On being settled with the fishery, the petitioner took possession. Full stop. The case projected by the petitioner in this petition is that when the tender notice dated 14/3/2022 was issued, the anywhere it is 68 acres mentioned.
My lord. Yes, my lord.
Anywhere
in
it is
tender
mentioned.
notice, it is mentioned 68.
Huh?
In tender notice, my lord, it was mentioned in 68, my lord.
Where is that?
In very first column of the tender notice. In
Where is the serial number? Your Kumotia?
number 1.
As per on the case that has been canvassed by the petitioner is that in the tender notice dated so and so, the AFDC Limited had projected that the fishery had an area of 68 hectares. Full stop. Accepting such projection as correct, the petitioner had prepared the bid value accordingly in anticipation that the petitioner would be able to do fishing in an area of 68 hectares of the fishery. Full stop. When the petitioner was under the assumption that the fishery has 68 acres of area as projected, for the reason that when the petitioner was handed over the possession, the petitioner was handed over possession during the rainy season, and it was not possible to measure the total area of the fishery. Full stop. After the area of the fishery dried up, the petitioner had found that some area of the fishery got stringed due to sandy water forces of flood and human encroachment. Full stop. The petitioner has projected that as a result, the operational area of the fishery has been reduced, has been made limited to only 40 hectares approximately. And as a result, the fishing activities had also been restricted, resulting in lesser production. Full stop. Though the petitioner has been regularly paying the
annual revenue
settlement amount to the respondent authority, the petitioner has faced severe crisis to raise the annual settlement revenue for payment to the settling authority. Full stop. The petitioner bringing the matter of lesser operational area of the fishery to the notice of the respondent authorities.
Then there is a physical violation made by.
And on the basis of his representation, a spot verification was done on 21/12/2024 by the jurisdictional circle officer. And after verification, a report was submitted to the respondent number 2 on 15/2/2025. Full stop. The petitioner has stated that he has, he has submitted a representation before the respondent number 2 on 27/2/2000 representations. two representation
And 8-4.
before the
4-8.
respondent number 2 on 27/2/2025 and 4/8/2025 with a prayer for refixation of the yearly revenue in respect of the fishery upon consideration of the report submitted by the jurisdictional circle officer as regards the actual area available to operate the fishery. Post of as the representations are not given consideration till date, the petition is before this court by the present writ petition. Full stop. Para. Mr. Sharma, Learned Counsel, appearing for the respondent number 2, has submitted that though he has no instruction as to whether the representations submitted by the petitioner have been given consideration till date, comma, he has submitted that if it has been found after a verification, spot verification by the jurisdictional circle officer that the area of the fishery is lesser than 68 hectares, comma, the same might be a relevant factor.
Also
Full stop.
considering the NIT, Lordship.
Huh?
And also considering the NIT. And that it is in respect.
Is relevant factor. Full stop. I have said only relevant factor. Full stop. Yes, submitted that at this stage, this writ petition can be disposed of with a direction to the respondent number 2 to take the representations submitted by the petitioner on so and so on board, and thereafter to consider the same by taking into consider the same along with the report submitted by the jurisdictional circle officer on 15/5
21/12.
21/12.
2020.
No, report.
Report, my lord, 21/12/2024. Page 86.
Annexer, কিমান আছে?
Annexer 7.
7 bracket
Page
লিখি দিব। Mr. Mohanto, Learned Senior Counsel, has submitted the petition, has no objection to the submission, has agreed to the submission made by Mr. Sharma. So he has further submitted that the petitioner, the respondent number 2, while giving consideration to the representation, shall also afford a hearing, personal hearing to the petition. Full stop.
Time limit. They are with us for 7 years, Lordship. They are with us for 7 years.
Let him continue.
Lordship,
Give a due
Time
consideration.
limit, Lordship. Time limit may not be.
In view of the submissions, taking into consideration the submissions made by the Learned Counsel for the parties, in the tender notice, it is found that in the tender notice, it was projected that the fishery had an area of 68 hectares. Full stop. The report of the jurisdictional circle officer. Where is that page?
87. 87. Most of the fishery in the
Reported that
It is sinking from, my lord.
A part of the fishery is completely dried up and silted due to seasonal flood of Kumotia River and there is shrinkage over time due to sandy water courses of flood and human encroachment. Full stop. As the petitioner has contended that he offered the bid value by taking into account that the fishery had an actual area of fishing, actual area of 68 hectares for fishing, comma, the matter of refixation of the yearly revenue has to given a is a has to be given a consideration by the respondent number 2. So in such view of the matter, comma, this court is of the considered view that the respondent number 2 shall take the 2 representations submitted by the petitioner on so and so and so and so on board, and after giving consideration to the report submitted by the jurisdictional circle officer and affording a personal hearing to the petitioner, the representation should be disposed of by a speaking order on the matter of refixation of the annual revenue of the fishery. So it is accordingly ordered. Post of it is further observed that the speaking order should be passed within a period of 1 month.
2 months, Lordship. 2 months, Lordship.
6 weeks. 6 weeks from the date of submission of a certified copy of this order by the petitioner before the respondent number 2.
Fine. Develop.
This order disposes of the report.
Your Lordship. Your Lordship, my lord, is aggrieved at not opening the technical bit of the my lord. My lord, in terms of the
Mental agony. You have mental agony now.
yes, my lord.
You are a contractor. You are having a
Monday we'll have the instruction,
Huh?
for instruction man, on Monday.
you are having a skin of rhino. Is it not? Hired Mr. S. Hawk, learned counsel for the petitioner, and Mr. B. Ugoi, learned additional advocate general for all the respondents. Full stop. Para. The case of the petitioner is that responding to a tender notice dated 14/11/2025, published by the respondent number 2, comma, he submitted his bid. Full stop. Although as per the tender notice, the date of opening of practical bids was 26/11/2025. But till date, the respondent authorities have not opened the technical bids in respect of the contract work and the reference post. Mr. Gogoi has submitted that he will obtain necessary instruction in the matter and has sought for listing of the case on
Monday, man.
Monday. Get it on Wednesday.
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 In
List
motion.
the case on Wednesday. What is another case?
No, man.
You need any copy? Any copy?
Oh, when is soft copy? It will move.
লিখে দিব। The Hawk Learned Counsel for the petitioner for an supply an extra copy of the document annexer to Gauhati during the course of the day.
Item 9.
Please, your lordship.
Hmm.
Matter related to non-payment of bills.
Non-payment of bills.
Petitioners are supplier of office materials.
Register being register proprietary. Is there any admissibility statement?
Your lordship, Annexus C, page number 122. There,
122.
122. There.
This is your representation.
Representation.
Full
amount was.
Others are what?
Others are annexer.
Annexer, these are work order or what?
Work orders.
Supply order.
B series is the bill.
Is there any admission? No.
Your lordship.
Is there any admission?
Yes, yes.
Where is that admission?
Your lordship, their full amount was 59,23,000.
Where is it?
92. And
Where is it?
they paid us 10 lakhs.
No, admission of liability. Statement showing. Let us see.
Our pair is.
What are these?
47 lakhs.
Statement. Oh, these are your prepared statements. Nobody has endorsed it. We'll keep it the issue of maintainability open.
Lordship.
Heard, Mr.
Asha.
R. Said, what? Saha, learned counsel for the petition. And Mr. S.R. Borua,
All the respondents.
learned junior government advocate for all the respondents, petitioners. The petitioners have stated that the petition number 1 farm deals supply of office materials and office materials, para 2, hardware articles, electric equipments, bamboo products, motor vehicles, spare parts, and accessories. Full stop. In the course of business, they had supplied motor vehicle spare parts and accessories to the office of the commissioner, Gauhati, pursuant to work orders issued by the said office, annexed as annexer A series to the repetition, from time to time. Full stop. The petitioner has projected that despite submissions of bills duly, the respondent authorities have not released the entire bill amount to the petitioner. So as a result, an amount of rupees 47,50,964 has remained outstanding till date. Full stop. As the said amount has not been disbursed despite approaches and submission of representation from the petitioner before this court. By the present petition, Mr. Borua, learned junior government paying for the respondents, state respondents, has submitted that the petitioner has only annexed the work orders and there is no admissibility statement from the head of the department in terms of the full bench decision in Kamserali, so and so reported in so and so. In view of non-annexation of any admissibility statement, the writ petition is not maintainable. Issue notice returnable on so and so. As Mr. Borua. Extra copies, 2 working days. In view of non-annexation of any admissibility statement from the head of the department in terms of in conformity with the full bench decision in Tamsway Supra, the issue of maintainability of the writ is kept open for consideration.
2003.
God bless.
Item 10.
Please.
I'll dispute and I would not need to deliver it to.
What is the case?
District Commissioner not when party is there. Now, again, I committed some mistake in page 3. The district magistrate Barbara has been made party.
What is your case?
Yes, but some work has been done. I done on.
That again you have done the same thing.
Yes,
And I think district magistrate, again you have done.
This is deputy governor.
Earlier, what was the mistake?
He
You are not a party.
Not made a party.
District magistrate, he will do law and order duty.
Yes, ma'am.
It is the district commissioner now. You file an amended
Yeah,
cost
I'll
title. Nowadays it cannot be.
Issue notice. I will.
No, it cannot be.
I will. I will file IMI.
No, many times no amended cost title is filed.
I will file.
File it. Mr. J. Borwin Ahmed, you should have seen it. J. Borwin, Learned Counsel for the petitioner, has sought listing of the case so as to file an amended cost title in the meantime.
On the madam.
List the case accordingly on. List the case on Swens.
9-2.
Well, after 1 week?
9-2 that I will file in.
No, not 9-2. 18-2.
Maybe earlier, madam.
Next Wednesday.
Tomorrow I will file. Tomorrow I will file.
Next Wednesday.
Yes, madam.
Item number 11.
May it please his name.
Yes.
This is the 4th round of litigation, my lords. Before, my lords, coming to the impugn orders directly, can I briefly narrate the facts, my lords? Then it will be. My lords, the matter pertains to settlement of Chiri River Minor Mineral Unit, my lords. It's a MMU, it's a mineral concession area, my lords. Initially, my lords, when the matter was initially filed, we were concerned with 2 units, my lords. Chiri Minor Mineral Unit, 2 units, sand and stone. Sand and stone, but this present writ petition pertains to stone only stone. My lords, what had happened, my lords?
Where is the area, district?
Chiri is in Kachar, my lords. Kachar. Chiri is a river, my lords. Chiri River, minor mineral unit. Well, what had happened, my lords, in the year 2014, my lords, 22/8/2014, my lords, the petitioner was settled with the mining unit, both sand and stone, for a period of 7 years, my lords, pursuant to a competitive bidding process, my lords. Now, pursuant to the settlement, prior to the settlement, although the settlement was for a period of 7 years, the environmental clearance was granted for 5 years, my lords. The EC was for 5 years, although the settlement was for 7 years. Hence, my lords, while the petitioner was carrying out the mining operations, the environmental clearance had expired, my lords, and he had applied for extension of the environmental clearance because the lease period, there were 2 2 more years remaining in the lease period, my lord, in the contract period, my lord. So although the application for extension of EC was applied by the petitioner, that was not granted for more than a year, my lord. It was not granted for more than a year, my lord, and therefore, since there was no environmental clearance, my query was suspended, my lord. The operations and mining operations were suspended. Now, when the mining operations were suspended, my lord, I made certain representations stating that not my fault. I have already applied for the environmental clearance and the environmental clearance is not granted. Nonetheless, my lords, after almost more than a year, the EC was granted and my mining was resumed. Now, since I missed a substantial period of a year, the DFO had extended the contract period. The contract period remained the same, 7 years. The period was same, only the date was extended because I could not mine during that period. Now, pursuant to the extension, after a few days, the DFO again issues an order saying that no, there cannot be an extension of the mining contract because there is no provision under the law. So mining could not have been, the contract could not have been extended. So you remove your men and material from the mining site and you vacate the mines. So thereafter, I filed and they issued a NIT, again for resale of the mines. Thereafter, I approached the High Court in the first round of litigation. I approached the High Court by filing a writ petition and a stay was granted on the NIT. Thereafter, my lords, the matter was disposed of by the Honorable Single Judge. The Honorable Single Judge had held, my lords, that although there was no provision for extension, there's no provision for extension of the contract, but still, because of no fault of the petitioner, he could not mine for a period of almost 1 year, that period where the mines were suspended, my lords. So therefore, the Honorable Single Judge had held, my lords, that at least I was entitled for a consideration of renewal, my lords. But at that point of time, I was not, in terms of the 13 rules, I was not eligible to apply for renewal because the renewal had to be applied before 18 months of the expiry of the lease contract period. So liberty was granted by the Honorable Single Judge in the first round of litigation, waiving off that period of 18 months. And the court had waived off the period of 18 months and allowed the petitioner to file an application for renewal, my lord. Accordingly, my lords, a renewal application was filed. When the renewal application was filed, my lords, we were called for a personal hearing and it was thereafter disposed of. Now, while disposing of the renewal application, the authorities, instead of considering the yardsticks for renewal, which is provided in Rule 19 and 20 of the 2013 rules, they came up with their own assumption, and they said, no, we cannot renew the mining contract because if we retender, it would fetch more revenue. Because renewal will only yield 25% more of the contract value, the earlier contract value. So we should retender, and it should be retendered because it will yield more revenue. So this was DHOR's Rule 19 and 20, my lords. And again, they had issued another tender, which is in question, my lords. The earlier tender was not acted upon. After my representation for renewal was rejected, they issue a tender again, my lords. Thereafter, I come to this court for the second time, my lords, the second round of litigation. My lords, while after filing the writ petition, my lords, in fact, the matter was taken up by my lords, my lords. My lords granted an interim order against staying the NIT, my lords. Because my lord has stayed the NIT and said there was material to be considered, so we'll consider the matter. So the NIT was stayed. This NIT is dated, my lords. Kindly, the second NIT is dated 29/04/2022. So that was stayed by my lords, my lord. And the matter was finally disposed of by the single bench, and it was held by the single bench, inter alia, my lords, amongst others. The court had held that the petitioner had a concluded and a vested right to get his renewal considered under clause 20, one of the clauses of clause 20. I'm not going, I'll show the rule later, my lord. He has a vested and concluded right. So he should be considered in terms or in light of that provision, my lord. And I was again granted liberty to file the second renewal application, my lord, in terms of the second order. And the second judgment also said that till the time a determination is made, my lord, on my second application, the tender would not be given effect to. Tender which was initially stayed by my lord, not be given effect to. So, my lords, I apply again, my lords, for renewal. And this time, my lords, there is the impugn order in the year 2024. They dispose of my renewal application. This time they come up with several different grounds, my lord, which was not part of the first earlier grounds, my lords. Not part of the earlier grounds to dispose of. Now, my lords, second time when the renewal was rejected, I again approached this court, my lords, by filing two writ petitions, sand and stone, my lords, for two. But however, my lords, a rule came to light that there's an alternate remedy, my lords. The rules provided for an appeal to the chief secretary against an order of the PCCF. So, my lords, in light of that rule, we withdrew the third ground of litigation, the third writ petition, and we took liberty from the court to file an appeal, my lords. Accordingly, my lords, an appeal was preferred on 9/8/2024. The date is relevant, my lords. 09/08/2024. And the grounds were the impugned second rejection was assailed in the appeal, my lords. So the appeal was pending, my lords, and I was called for hearing, my lords, 9/8/2024. I filed the appeal in the month of January 2025. I was called for a personal hearing. Thereafter, my lords, the appeal till date has not been disposed of. However, my lord, all of a sudden, in the month of December, I come across a caveat, my lords. Caveat filed by the private respondent, my lords, saying that the stone mineral mining unit, that tender which was stayed, my lords, the 2022 tender, my lords, that has been given effect to, and a LOI has been issued to the respondent number 7. My appeal is still pending, my lords, before this chief secretary, and for a period of more than a year, they had not acted upon, more than number of years, my lords, they had not acted upon the tender. All of a sudden, my lords, in the month of, on 30/11/2025, 30 November 2025, they issue the LOI to the R7, my lord, respondent number 7. Thereafter, my lords, I have filed this writ petition again because sand has not yet been.
That LOI was in response to NIT dated what?
NIT dated 2022. My lords, the NIT, the second NIT is dated 29/04/2022. 29/04/2022. And LOI was issued on 30/11/2025. Now, my lords, I have in this instant writ petition, I have challenged the LOI, the order of rejection of my renewal, and the entire tender process as well, my lords.
Out of originally contemplated 7 years.
Yes.
For how much time you had operated the mine?
The mines could not be operated for a period, my lords, more than a year.
What is the amount? What is the period, exact period remaining?
Exact period. Exact period, my lords would find.
Because it is 2014, you say.
Yes.
How much period you have enjoyed till then?
Yes, my lord would just give me a moment, my lord. The initial period was from 1/9/2014.
Because you said
yes.
5 years
Exactly.
Environmental clearance.
Exactly.
That time you operated.
Yes.
And thereafter when it was not renewed,
yes.
you could not operate.
I have to calculate the exact date, but it can be calculated.
So originally contemplated is 7 years. How much you have operated?
7 years, yes, my lord.
How much you have operated?
6
5 years is clear. 5 years you operated.
Maybe lordship, I'll come up with the exact calculation. 6 years, maybe not more than that. I could not operate for a year or more, my lord.
So basically, your grievance is only to the about 1 year.
Yes. Now the grievance has changed, my lord. That was the grievance in the first round of
initially that you could not operate the mine or what is mining lease for a period of 7 years. Full period of 7 years.
The initial grievance. That was the initial
grievance.
When I approached this court.
But core of the grievance is that
I should
be permitted to operate the entire period of
Now,
7
my
years.
lords, now, my lords, because in the first round of litigation, the honorable court had held that I was eligible to file an application for renewal. Now
Right.
the grievance is the renewal should have been considered in terms of the rules, which was not considered. That is the grievance, my lord. The renewal ought to have been considered in terms of
What
Rule
is, what
19.
is the consideration given by the court? Because renewal is what? After expiry of the lease period, right? So that 7 years
Yes.
is impliedly gone.
Yes, yes.
That 7 years is impliedly gone.
Right, correct.
Right, because there is no provision for
Extension of
extension.
the contract period.
So impliedly that is over.
Yes.
7 years gone.
Yes.
Your right of renewal
Yes.
is to be considered vis-a-vis the action of the
Yes.
forest authority.
And in terms of Rule 19 and 20, because it is circumscribed, my lord, the consideration cannot be.
Let us hear.
Yes,
the
just
other-
one point I want to place, my lord. My lord, in the main case, my lord, insofar as the rejection of renewal is concerned, my lord, there are a lot of issues, my lord, that has to be addressed. But I'm praying for an interim order, my lord. I'm praying for a stay on the LOI. Lordship would give me a moment. I'll just argue on the interim part, my lord. My lord, Lordship has seen, my lord, my first renewal application was rejected by the respondent authorities, claiming that
You should fetch higher value.
because tender would yield a higher value. Now, my lord would just see the conduct of the respondent authorities, what they have done, my lord. Lordship, just give me a moment, my lord. My lord, they have settled a tender pertaining to the year 2022, when reserve prices were declared in terms of that year in the year 2025. In the year 2025. Which is grossly against public interest, my lord. Now it is
Same thing, allowing you also at the old rate will be grossly against public interest.
25% more, my lord. 25% more, and that is by way of a direction of the court.
Let us see it.
Yes, and one very crucial aspect, my lord. One very crucial aspect, my lord. The LOI could not have been issued in the first place, my lord. Lordship, may kindly take up the additional affidavit for a moment, kindly, my lord. Or before that, my lord, in the writ petition,
Tell me if at the time of issuance of the LOI,
yes,
was there any kind of restraint order?
Yes.
Which is that?
Yes, there's no restraint order, but they could not have issued. That's I'm coming to that point only, my lord. Lordship, may first take up the NIT, the short NIT, my lord. It's in the writ petition. My lord would come to page 125. 125, my lord. My lord has it, my lord. This is the NIT, my lord. If my lord turns the page 126, my lord. Last date of submission of technical bid and price bid. Stage 1, my lord has it. 126. My lord, may kindly note the last date. 23/05/2022 up to 5 p.m. On that day, my lords, the interim order was passed by my lords, staying that tender, my lords. So assuming, my lords, the LOI has been issued, it can be assumed, I'm so sorry, my lords, that the respondents along with the other bidders had already submitted their price bids, my lords, on 23/05/2022.
Where is the order passed?
Yes. 23, the order, my lord's order would find page, my lord, page 126, my lord. 127, 127, just the, no. Yes, my lord. Page 132, I'm so sorry, my lord, page 132, annex of S. And the relevant portion, my lord. Paragraph 5. Paragraph 9. Having regard to the same, it is provided that till the returnable date, the respondent authorities shall not proceed further with the bidding process after closure of the submission of bids. So my lord had also allowed submission of bids, meaning thereby bids were submitted till 5 p.m. my lord, but they were not allowed to proceed further. 23/5. So bids were submitted on 23/5, my lords. 23/5/2022. Now, if I may kindly draw my lord's attention to the additional affidavit, my lords.
Then what happened? That is disposed of.
No, that is disposed of.
When?
Yes, that is again, my lords, page 138. The relevant portion, page 152.
152.
Till such determination is made, the impugned e-auction shall not be given effect. So till my renewal application is not considered, the tender was, I'll give the timeline. Thereafter, again, my lord would
Then
note.
where is the rejection?
Rejection is again, my lords,
Application?
22/7/2024.
Page?
Page 172, my lords. So it was operating till 22/7/2024.
That is rejection of
Page
the
172.
renewal application. That is 172.
172.
22nd July 2024.
So the interim was operating
that.
22/7/2024.
Up to that.
Up to that, my lord. Lordship will note it, 22/7/2024 minutes.
And then?
Now, may I kindly draw my lord's attention?
Then what is this petition?
Then again, the second writ petition, which I
Against rejection of your.
I withdrew that because there was a provision for appeal, my lord.
Okay, then you preferred appeal.
Yes. Appeal is dated, my lords, 9/8/2024.
9/8/2024.
Yes. Appeal is still pending.
It is a statutory appeal.
Yes, statutory appeal.
Where is that provision?
Under 68(2).
Oh, Peter.
68(2) of the Minor Mineral Concession Rule 2013.
Hmm. 68.
68 one. Unless otherwise provided.
Before whom?
Before the Chief Secretary, my lord. If it is passed by the director or the principal chief, so appeal shall lie before
That
the
your renewal application was rejected by whom?
the PCCF, my lord, the competent.
PCCF.
Yes.
Lie before the government.
Lie before the government, my lord.
Lie before the government.
And since the government is represented by the Chief Secretary, appeal was preferred to the Special Chief Secretary, the Forest.
Yes.
Yes. Now, my lords, my lord has seen, my lords, that the interim order was valid till 22/7/2024, till the date when my renewal was rejected for the second time.
22/7.
22/7/2024. Bids were submitted on 23/5/2022. That was the last date. On the same day, interim order was issued. Now, if my lord takes up the additional affidavit, lord. My lords, the NIT, what I have shown, my lords, that is the short NIT. And for all NITs of the Forest Department, there is a standard bidding document, my lord. For if my lord comes to page 254 for a moment, my lord has it. Bidding documents for mining contract area. Now, my lords would come to page 258 for a moment, my lords. 258. Just to give some perspective that these are the terms and conditions which has to be followed, my lords, while settlement of a mining contract area. Definition, my lords. 2.1 Act means the Mines and Mineral Development and Regulation Act. 2.5 competent authority to float such tenders under the rules. Department shall mean the Forest Department and its officers who deal with competitive bidding process of minor minerals as specified under the rules. Rules would mean, my lords, the Assam Minor Mineral Concession Rules 2013 and its amendment. Again, my lord, the bid due date, my lords, that is very important. I'll come to it later, my lord, bid due date. Now, if my lord directly comes to page 278, my lords, 278. Now, they're not thinking about revenue, my lords, while settling it after 3 years, my lords. And my 278 for a moment, my lord. Validity of bids. My lord has it, my lords. 278, clause number 1311. My lord has it. I'll read it, my lords. The initial price offered shall be valid for a period of 250 days from the bid due date if the preferred successful bidder is not declared within 250 days from the bid due date, then the e-auction process will be annulled and the state government competent authority will refund the price bidding documents of the bidders. Here it says the bid due date. So my lord has to refer to the definition to see what is the bid due date.
What is the bid due date?
Yes.
23/5/2022.
Yes, that's the bid due date. My lord, again, may kindly, both of us in my lord, according to me, it is the date when the bids were submitted. Bid due date is there in 258, my lord. Again, it says bid due date means the date as mentioned in clause 11 by which the technical bid and the initial price offer is required to be submitted in accordance with clause 8. If my lord comes to clause 11, page 272, it says last date of submission of bid is the bid due date. Clause 9, last date of submission of technical and price bid.
Which page?
Page 272, it starts, my lord.
Yes.
Bid due date means, as mentioned, the technical bid and the initial price offer is required to be submitted.
272. Timetable is there.
Yes, timetable. 273, clause 9. Last date of submission of technical and price bid. 273. So, my lords.
What is Rule 8?
Rule 8 is the entire process of tender, my lords. Auction process, my lords. Therefore, my lords.
Clause 11. So you want to say that after 22/7/2024,
yes,
till the date when this,
if we add
that mine was settled on 30/11/2025.
Yes, yes. So, my lords,
so 250 days expired.
What I'm trying to say, my lords, if we add 250 days to 22/7/2024, that would be 28/03/2025. That would be the last date till which a bid submitted by any of the bidders would be valid. And after the expiry of the validity, the LOI could not have been issued, my lord. There's a judgment also, my lord. And it is their own bidding document that it has to be annulled. And there is no power of relaxation, my lord, to see.
Okay. Come back.
LOI is the ground, my lords, that the LOI has been issued in clear violation of their own.
Who is LOI?
LOI, my lords, I don't have the LOI. It's 30/11/2025 because of the caveat, my lords. From the caveat, the number and the date of LOI. 30/11.
And what do you say? When it 240 days?
250 days expires on 28/03/2025, as per my calculation. From 22/7/2024 plus 250 days. So, my lords, first ground, my lords, that the bid bid was issued after the bid
I have
validity.
understood.
Yes, yes. And second, the second ground, my lord, for assailing the LOA, it is grossly against public interest, my lords. I'll come to that. Why, my lords? If my lord takes up the rules for a moment, kindly, my lords. There's a procedure, my lords, for settling mineral contract areas. My lord. If my lord takes up the rules and comes to rule 32, my lords, there's a duty cast upon the PCCF, my lords, to determine the reserve rate. Page rule 32, 33, my lords. Should be page 266A of the book.
Hmm.
Yes. My lords, the
Wait, this is 29/4. It was 29/4/2022.
the NIT is 29/4/2022. Last date was 23/05/2022. Stay was granted on the same day. The judgment was passed on 22/04/2024. And the decision on renewal
Hmm.
was on 22/07/2024.
Decision on renewal?
22/07/2024.
Okay, okay. Let us hear, then we will hear you like if required.
And last, my lord, this last point, my lord, that determination of 32 is, my lord, kindly.
I have seen.
33, sorry.
I have seen.
Yes. And
it is there reserve price otherwise.
Yes, yes, yes. And
otherwise, it is
and-
there
and
in page 125.
when the chief secretary is in session of my appeal, my
That
lord,
I have
for 1 year,
understood.
a junior authority,
No time period is fixed there in the rules for disposal of the appeal.
Yes, ma'am.
So he can sit over the appeal
Ideal course
for
would-
indefinite time.
No, certainly not, my lord. Ideal course would be, my lord, to allow the appellate authority to pass an order on the appeal, my lord. And otherwise, my lord, if I may take your lordship to page 48 for a moment, my lord. Was the, my lord, final settlement made in favor of the petitioner in 2014, my lord. If my lord sees, my lord, the first paragraph at the end, my lord. Within 7 days from the date of issue of this letter, with effect from the original period was from 1/9/2014, 1/9/2014 to 30/9/2021. Then my lord will kindly see just below that, my lord. Serial number 2, offer bid value for 7 years. 3,78,84,000 was the amount at which it was settled for 7 years with the petitioner, my lord. If we, my lord, now turn to page 229, my lord. This is, my lord, one of the orders impugned, my lord, by which, my lord, LOI has been directed to be issued. If we see, my lord, third paragraph, the paragraph starting with the word therefore, 229 page, my lord. In exercise of powers conferred under Rule 37 of the so-and-so rules, read with amendments, the Divisional Forest Officer, Kasar Division is directed to issue letter of intent to Sri Devojit Das, being the successful bidder among the bidders in competitive bids received in response to the notice inviting tender dated so-and-so for granting mining contract in respect of Sri River minor mineral unit for a period of 7 years for extraction of 7,000 cubic meters of stone at his offered price success. It is now, my lord, it has gone up to 15 crores, my lord. And because of this repeated litigation, my lord, I'm not justifying our stance, my lord, every cent. Since 2022, already 4 years have gone. And he's, my lord,
What is 37?
37, my lord, Rule 37, my lord. Payment of bid amount. No bid shall be regarded as successful unless accepted by the officer competent to accept bid tender in accordance with the provisions of Delegation of Financial Powers Rules, 1999 of the state. The highest bidder shall be required to deposit an annual amount equal to 25% of annual dead rent, contract money as a security. These are, my lord, basically payment schedules, my lord. Now, my lord, if we, my lord, turn to page 84, my lord. Sorry, 83, 84 and 85, 3 pages, my lord. My lord will take note of the date, my lord. Initial 5 years, there is no dispute, my lord, he operated. And 48, so it says, my lord, with reference to the subject cited above, and as so Assam issued environmental clearance, the second phase, my lord, for the rest quantity.
Page 85.
83, my lord. With reference to the subject cited above, and as the SCIAA, Assam issued environmental clearance for the rest quantity by letter number so, and as the final settlement order issued write this office letter number so, Siri River Minor Mineral Unit so, for 7 years is needs to be modified and resettled due to non-receipt of environmental clearance in time from the authority. Hence, Siri River Minor Mineral Unit Stone is resettled for payment of remaining 8 keys for 2 years. So it's resettled, my lord. My lord, kindly take note of the date, my lord, 13/11/2020. As per the rate quoted by you, you are directed to deposit keys money as per settled below for extraction of balance amount quantity of 24,000 metric cubic meter for 2 years. Annual was 112,000. So for 2 years, it was 12,000 cubic meter. However, this office letter number so for suspension of extraction operation of stone from Siri River Minor Mineral Unit is withdrawn subject to deposit of dead rent. So if we, my lord, come to the bottom of the page, my lord, payment schedule, last third, my lord, 5th, 6th, 7th, 8th. So date of installments were, my lord, 17/11/2021, 17/2/2021, 17/5. 2022, 17/8/2020. Now, if we, my lord, turn to the next page, my lord, we buy this, my lord. Earlier order was, my lord, 13/11. The next page is, my lord, 19/1/2022. So almost, my lord, 14 months, 13 months, my lord. Almost 14 months, actually. After this, this order was issued, my lord. He was operating in the meantime. With reference to the subject cited above, it is to inform you that the contract agreement will no longer be valid at the end of this case period. In this connection, there is no provision in the AMMC rules 2013 for extension of mining contract area beyond the original contract period. So this was, my lord, cancelled. Then, my lord, will see page 85. With reference to the subject cited above, this is the letter written by the petitioner to the DFO, my lord. I have the honor to inform you that as per your letter mentioned above, that the agreement is no longer valid and I'm not able to pay the next keys, but I have received a message in my mobile mentioning that my next keys is due on 17/2/2022. And now I am in a confusion that whether I have to pay the keys or not. Moreover, you have directed me to remove my man and machinery on before 16/2/2022, he was operating, my lord, till 16/2. So it's a matter of hardly, my lord, 10 months. And I have already, and he has not deposited for the remaining period when he has not operated, my lord. And I have already informed you various times that I have not been able to operate the mahal due to COVID-19 pandemic situation and various bonds. And at present, the bond is still going on from 2012 to 2021, which is well known to you. Further, that I have a huge stock of stone and sand, which is still remaining to lift. And I am praying to you to.
But those things perhaps were swept under the carpet because of the subsequent judgment.
Yes.
What he has a right to seek for renewal. That is his case.
Yes.
And his application for renewal was rejected by the original authority. Now, thereafter, he has an appeal pending. That is first point. That should be disposed of. That is one.
Exactly.
Secondly, in the retender notice which was issued, he spoke about bid value, a bid due date.
There are all along interim orders, my lord.
All along that let us remove by the normal situation, say Land Acquisition Act, wherever it is stand any interim order of the court is operating stay, that period is to be not considered. Let us not consider that. Even then, 250 days or what he said.
Thereafter, he
that
filed an appeal.
expired.
Thereafter, he filed an appeal. Appeal is also pending.
Appeal, there is no stay order operating.
There is no stay order, but appeal is pending. So
Appeal
that
is
is why
pending.
perhaps we decided not to proceed till the appeal is decided. But it is also true that appeal is yet to be decided.
Appeal is yet to be decided.
Yes.
And in the meantime, he said that though the retender notice was issued, as per the terms and conditions of your own bidding document, the bid value could have survived till 250 days. So after rejection of his renewal application,
Since
right,
his appeal, it is his own appeal, which is a continuation of his earlier application. So that stay, we applied
right,
on ourselves.
till rejection of his renewal application, that period you remove
My lord.
out of consideration. Till then, he says that 250 days expired. So by your own terms, that bid
should-
value
Has expired.
offered earlier could not have survived.
My lord.
And on that basis, you could not have settled the mine in favor of the successful bidder.
True, but
The course open for you is to retender it.
that is
By your own terms. That is what he has indicated.
Exactly. So to counter that, my lord, my submissions would be, there was an interim order operating till the application for renewal was decided. Since immediately thereafter he filed the appeal, my lord, we treated that interim order to be in operation, my lord. Only fault that we have done is that we have not decided the appeal and passed
Let
this.
us not say that the interim order is operating. How can it be said? It is not a proposition.
And secondly, my lord,
Appeal may have the appellate authority may have the right to pass an interim order.
Exactly.
Sometimes it is not there. I don't think it is there.
Had it been there, he would have done it, my lord.
That authority should have yes.
And second submission would be, my lord, he has not participated in the tender process, my
I
lord.
could not participate, my lord.
He could have, my
I
lord.
didn't have the opportunity to
could have.
participate.
My lord, kindly say
That is also one of the
my
grievances.
lord, it is his private, my lord, damage that is caused to the petitioner. It is his private grievance, my lord.
Right,
My
right.
lord, kindly also appreciate, my lord, because of this litigation since 2020 to 26, 4 years, my lord, state is devoid of any revenue from that.
That I also know. I have taken
So,
into
my
account. That is
suggestion-
the first question, how much he has operated? That is the
Exactly.
first question.
He could, there was remaining period of around hardly 10 months, my lord.
Right.
For that, my lord, he has successfully, my lord, closed
It is
this.
not that everything is his own doing.
Yes, ma'am. True.
It is a doing of the responsible authorities also at the same time. It is not that a one-way street.
No, my lord, kindly appreciate. The first judgment of this honorable court, the relaxation was created for the petitioner under Rule 19, my lord. Rule 19 says renewal application is to be submitted before 18 months.
That condonation of 18 months or whatever,
Yes.
if you are not aggrieved,
Yes, my lord. We
that
accepted
is
that
gone.
order. We accepted
That
that
is a
order.
foregone conclusion now.
Yes, my lord. We accepted that order, but that is not our fault, my lord. We accept. It is not that only because of our fault he is not being able to operate. If I may submit, my lord.
It is an order of the court.
Yes,
Instead
true,
of
my lord.
challenging
We have accepted.
that condonation of 18 months,
We could have
whether it is not
We have accepted that.
permissible under the law.
Yes.
Because court does not have otherwise. The law is that
In fact,
if the statute does not provide for any condonation of period of limitation, you could have challenged
It
it.
was condoned, my lord.
That you have accepted. That is a foregone
Then, my lord, we
conclusion now.
decided, our first decision was that there is a huge revenue difference, my lord. That was again interfered, my lord.
That is in the mind of the court.
Yes,
But
my lord.
still, by the operation of the terms and condition, 250 days, that is gone.
If I may suggest, my lord, let the appellate authority decide the appeal within 7 days. Keep the writ petition pending, my lord. Till then, status quo may be maintained. That will, my lord, protect everyone's interest. State's interest is also.
Has he been afforded any hearing
Yes.
in appellate?
Yes, yes. He was
Already
I pleaded, my lord.
personal hearing
Personal
has
hearing.
been afforded.
Personal hearing. By
Within-
the
within
chief
two-
secretary, my lord.
It is
Special chief
Within
secretary.
10 days, my lord, special chief secretary will take a call on his appeal. Till then, status quo. That will, my lord, I think protect everyone's interest, my lord.
That may give rise to second cause of action for him.
Well, for him, my lord, there is no dearth of cause of action, my lord. From 2022, he has filed, even after the, my lord,
No,
my
fifth
lord,
round, fifth
after the
round.
rejection order, my lord, he filed 2 repetitions.
Fifth round. Fifth round.
My
Fifth
learned
round, my
For
my-
him.
My senior colleague is blaming the court, my lord. Courts have passed orders, my
No,
lord.
I'm not blaming. I'm
He's
just,
saying government, we couldn't do it because
I'm
there were
just-
orders by the court.
I'm just appreciating my learned
My lord,
friends, my lord. Yeah, my lord. efforts, my lord.
My lord,
to
see the
create
list,
cause of action, my lord.
22 tender settled in 2025. And they say it would yield more revenue.
That, if you argue that,
No.
that is the revenue, if you argue, then
No, I'm not arguing.
In that Dunlop case, my lord.
public interest
Yes.
comes in.
I could not participate
My
also.
lord,
my
on
lord.
the point of interim order in that Dunlop case, my lord, it has been
So
clearly held,
if
my
the
lord.
public interest comes in between and revenue comes in, then there will be.
Exactly.
They cannot
might
lie.
be
I think this will
death-
protect everyone's
death
interest.
knell for you.
Yeah, it's status quo, my lord, still the appeal is decided.
Okay.
Within 10 days, appeal will be decided. my lord.
That the chief secretary would take a call. Or lordship may direct within 10 days or as soon as possible.
Who is in season of the appeal?
Special Chief Secretary, Environment and Forest Department. my lord.
Today is what? 10th. 11th.
Appeal from what I've said, 8/181.
Anyway, we'll issue notice returnable by 25th. You submit file dusty also
My lord.
for
I
the
can-
private one.
Oh, yes. my lord.
Otherwise, again.
Although I received the caveat, my lord.
He might, caveat.
I received the caveat, my lord, but I
Where
checked
is
there is
the
no
caveat?
caveat. There is no caveat. I've checked in the online. I received the copy of the caveat. It's annexed in the writ petition.
Where is that?
It's in one page number.
One is left again, sir.
एक सेकंड वोट बोल रहे कैविएट कौन बोल मतलब पेज 222 and there are clear pleadings that I received the caveat. I came to learn when we filed, my lords, when we checked, there was no caveat, my lord. But we received the envelope, my lord, containing the caveat.
Where is the last page? That name of the council is mentioned. Otherwise, you don't have the full page.
It's there, my lords.
Where is that?
Suprotim De Purokaisto, Advocate, Gauhati High Court.
6, what say?
Which page?
Page
Yes.
226, my lord. Paragraph 4.
Then, my lord, instead of issuing notice, my lord, may post it after 10 days. In the meantime, special secretary will decide the appeal, my lord.
I'll take steps on the private respondent since he has not filed the caveat, my lord. Can check court.
Let us put him on notice.
Well.
Returnable 25th. He will file by dusty.
Well.
So that in the meantime, you can decide the appeal.
Well.
Thereafter, we'll proceed further. Mr. P. Mohanto, Learned Counsel for the petitioner. And Mr. P. N. Goswami, Learned Additional Advocate General. Said by Mr. R. Gugoi, and Standing Counsel for his department. For the respondent number 1, 2, 3, 4, 5, and 6.
My lord, we are appealing for all, my lord, except
7.
7.
Para. One of the grievances raised by the petitioner in this writ petition is that his appeal under section
68, my lord.
appeal under section
68-2,
68 within bracket 2 of the Assam Minor Mineral Concession Rules
2013.
within bracket 2013 rules for short against an order dated
Order dated, my lord, the appeal preferred against the second impugn order 2207-2024.
against an order dated 22/07/2024
24.
rejecting his application for renewal of the mining concession.
Mining mineral concession area.
Minor mineral
concession
mining concession
area. It's a contract, mining contract, not a lease.
mining contract
Mining contract.
for CD.
Chiri River Minor Mineral Unit. Stone. Bracket.
Has not yet been given consideration despite filing of the appeal on
Appeal preferred on 9/8/2024.
9/8/2024. Full stop.
And
Yes, further. the
personal
petitioner
hearing was also
contended
accorded.
that and after affording a personal hearing to him.
On 30/01/2025.
Full stop. The other grievance of the petitioner is that the respondent authorities had published a long e-auction notice on 29/4/2022 for settlement of same river minor mineral unit stone within bracket stone for a period of 7 years. Post of. With last date of submission of bid on 29/4/2022.
No, 23/5, my lord, last date.
23/5/2022, which was the bid due date. Bid due date.
Bid due date.
Bid due date. Full stop. But it is contended that if the period during which the interim order was operating is kept out of consideration, then a period of 250 days had expired on 28/3/2025 in terms of clause
1311, my lord.
13 within bracket 11
13
of the bidding
Tender.
document published with the long e-tender notice dated 29/4/2022. Full stop. The petitioner has further canvassed that it was only on 30/11/2025 the mining key, it was within bracket stone. An LOI was issued in favor of the respondent number 7. So, according to the petitioner, issuance of such LOI after expiry of 250 days from the bid due date is clearly illegal. Stop. Mr. Goswami, learned additional advocate general, appearing for the respondents, has submitted that the appeal, the special secretary to the government of
Chief Secretary.
Chief Secretary to the government of Assam,
Environment and Forest Department.
Environment and Forest Department, is in origin of the appeal. Since one of the grievances of the petitioner is that the appeal preferred by him as against rejection of his renewal prayer is not disposed of, it may be left open during the pendency of the repetition to take into consideration the pending appeal and to dispose of the same by a speaking order first. He has further Mr. Goswami has also controverted the submissions made by the learned counsel for the petitioner as regards expiry of bid due date. Post of. He has further stressed on the loss of revenue to the public exchequer. They are not committing anything. Issue notice returnable on 25/2/2026 as Mr. Gogoi, learned training counsel, Excise Department has appeared and accepted notice on behalf of the respondent number 126, formal notice, not extra copies by tomorrow. Post of. You inform respondent number 7. Steps respondent number 7 by speed post. In addition, as paid for, trustee and compliance affidavit on or before the return. It is observed since it is as admittedly the appeal preferred by the petitioner is pending before the special secretary to the special
Chief Secretary.
pending as on date, comma, pendency of the repetition. It is observed that pendency of the repetition shall not be a bar for the appellate authority to consider and dispose of the appeal
Well, it is-
on or before the returnable date by way of a speaking order.
Instead of an observation that pendency is not a bar, my lord may direct him to decide it directly.
Okay. This court directs, comma, in the interim, that the appellate authority shall consider and dispose of the appeal.
Before the next
In
return.
on or before the returnable date. Before the returnable date, in terms of the observations already made by this court in the judgment and so give it whatever is there. Because he is bound by that,
Yes, yes,
those
yes.
observations.
Yes.
What are the judgment?
Yes, my lord, the judgment
Which
and
one is
order,
relevant?
judgment and order dated, my lords, 22/04/2024, annexure
in?
T,
Passed in
passed in WPC number. I'll give the number. There were two repetitions shown.
and the 2013 rules. 2013 rules.
Well, the LOI has to be stayed, my lord,
No, no,
next day. Well,
till-
he,
Till the appeal is decided.
LOI has to be stayed.
Not LOI. Till the appeal is decided, we'll make it.
I shall not, full stop, having regard to the facts and circumstances obtaining in the case hand, comma, it is observed that there shall not be any further process subsequent to the LOI dated so and so for settlement of the so and so.
Till appeal is decided, madam.
Till the returnable date.
Madam.
Yes, and my submission, my lord, settlement has not yet been granted till date, my lord. Settlement order.
So I said pursuant to settlement or towards settlement. Pursuant to LOI.
So many forthcoming cause of action from Mr. Mondo. Deeply obliged.
Very grateful, my lord.
12.
My lord, this pertains to a contract for cleaning of the Rangia railway station, my lord. Contract I had entered into on 20th of June, 2024.
Where is that?
LOA, my lord, is at page 56.
Page 56.
Page 56.
This is LOA. 20 June 2025.
My lord.
Okay.
We commenced the work, my lord.
What is the work?
The work is for cleaning of the Rangia railway station.
Where is that? Manpower based.
Manpower based cleaning.
Mechanized cleaning contract.
Contract.
Of railway, Rangia railway station for a period of 3 years.
3 years.
So up to 28.
Yes.
Okay. Then?
So within the initial period, my lord, there were some observations raised against me that my labors are not registered and police verification, etc. has not been done. Locker facility, etc. has not been provided. That had subsequently been met, my lord, because police verification, etc. and locker facility, space, etc. railway had to provide. During that period, some penalty was also imposed, my lord. The dispute is not on that.
What is the issue order?
Page 80, lordship would come.
80.
Page 80, they issue me a 7 days notice
For
termination, my lord.
notice. Was given you in this year, but you have taken no action to improve the quality. You have given 7 days no comments, service. What is 7.4?
7.4, my lord, is the termination procedure.
Where is that?
Lordship would come to page 132. There are specific deficiencies, my lord, pointed thereof.
Which one?
In my case, my lord, nothing is specified as such. But then we understand maybe it might be, my lord, instructions of the manager and contravention of any provisions of the contract. It would be Z, because others squarely do not cover my case.
Performance.
Understand it to be Z, my lord, because otherwise other conditions are not probably squarely attracted.
Performance notice after service was given to you 10/11. It was preceded by another notice.
Yes, my lord. 10/11 is at page 76. This was not a statutory notice or the notice and visits under the contract. 10/11, my lord, is at
And
page 76 annexure.
or comply such and
But desirable standards of service have
shall
not
be
been
entitled
achieved.
to serve by writing. This was page 80.
Hello.
Then?
And my lord, I furnished the reply thereafter. My lord, that annexure Q, page 90.
90. Okay. Then?
Explaining, my lord, all the different aspects and things.
Then?
And my lord, finally, I'm terminated, my lord, on.
No, nothing in between.
Nothing in between, my
Huh?
There are developments, but
No, nothing, no notice in between. Before, in between.
After the 7 days notice, my lord, they have terminated.
In between page 80 and page 116.
My lord.
There was no notice.
There was no further note. I gave
No
a reply.
notice.
I gave a reply, my lord, on 26/12/2025. Regarding all the different issues that had come up, police verification, reform, disposal, authorization, complaint register, inspection. And ultimately, what I understand is that from the termination.
Where is the
notice-
tender document? It is annexes in full. Not annexed.
The bid document is there, my lord.
You have read 7.4 page, which page? Page
132, my lord. 132.
32.
My lord. That is the relevant section relating to
Determination of
determination
contract. Now, it is come to page 133.
Hello.
7.4.1. Performance notice.
Hello.
Right.
My lord.
In the event of the above, all the clauses, preceding clauses, right?
Yes.
The manager of the railway may serve the contractor with a performance notice as per Annexure 12. Where is that available?
That format is the
Okay.
termination notice.
Now,
7 days notice.
Just a minute. 7 days notice. Page 80.
Page
80. Just let us read into it. Right. First one. Performance notice under clause 7.4 of the general condition was given to you under this office letter of event number 10/11/2025. Right. So this is the performance notice.
Lordship.
That is contemplated in page 133, clause 7.4.1. Right.
Yes.
Then this one.
Page 80.
Then clause 2. You are hereby given 7 days notice in terms of clause 7.4.
Hello.
That you will find at clause 7.4.2.
4.2.
After delivery of the performance notice to the contractor, if he does not proceed to make good her default and carry on the services or comply with such direction as aforesaid to the entire satisfaction of the manager, manager shall be entitled to serve 7 days notice as per Annexure 14. Perhaps this is Annexure 14.
This is Annexure 14.
Right. Further in writing, to either commence the service or improve the quality of service to the prescribed standard.
Hello.
Right. the failure to do so shall entail a termination notice being served under the hand of the manager to rescind the contract as a whole or in part or parts as may be specified in such notice. Right?
Hello.
That is next. If no action to commence the service or improve the quality thereof is taken by the contractor within 7 days notice period, then the final termination notice as per Annexure 15 shall be issued. Meaning thereby, there must be another notice perhaps. That is why I
No,
wanted
after 7 days notice, railways, they follow this particular format. After 7 days notice, if you don't make good, they automatically terminate the contract.
No. 7.4.
Hello.
This was the second notice under 7.4.2. Right. Now we read.
After delivery.
Third line. The failure to do so
Hello.
shall entail a termination notice being served
Hello.
under the hand of the manager to rescind the contract.
Hello.
Right.
Hello.
No prescribed format. 7.4.3.
3 is the termination.
If no action to commence the service or improve the quality of service thereof is taken by the contractor within 7 days notice period, then the final termination notice. So one is termination notice, one is final termination notice. Which one is correct? Okay. Let us see your impugn.
116.
116, my lord.
116.
Do you have the bid document with you? This prescribed format?
The format contract. Pura contract. Directly soft copy. I have a hard copy, my lord, as well. I have a hard copy of the complaint. Otherwise, soft copy is there. It's 16 days, it's a termination notice. It's 4.7.7.4.3. But then the wording is that it's not a notice, it is a final decision, my lord, that is.
That is why I am asking you whether in between there was another notice.
There was nothing, man. I replied saying that this is how I am trying to make good defaults. After 7 days, my lord, they said that under 7.4, your contract is rescinded.
A notice for termination of above contract shall be issued. Yes, Mr. Roy, is it a notice?
Lordship,
There has to be, this is a termination notice.
Lordship.
The final termination notice contemplated in this
Lordship.
clause perhaps is missing. If I have understood correctly.
Hello.
Where is the page again? I have lost.
134, my lord.
134. No. 134.
The failure to
There is a termination notice, then there is the final termination.
That is one aspect. But then we have understood it to be final because they
that
said
was
that
the
they
7 days
use the
notice
word
was
rescind.
7 days notice was already given to take it. If you do not improve that 7.43 as 7 days notice has already.
First it will start with
performance.
7.4.1 performance notice.
Lordship.
Now
There
come to in the event of any of the above and any of the said clauses, manager on behalf of the railway may serve the contractor, right?
Lordship,
A performance notice in Annexer Roman 12,
Lordship.
right?
That is
Now
page.
come to
Page
page
76.
80. Come to page 80,
Lordship.
first paragraph.
Contract-
Performance notice under clause 7.4
Lordship.
of general condition was given to you under this office letter of event number 10 11 2025. But you have not taken no action, right? You have
Right.
taken no action. Then
You
you are hereby given 7 days notice in
Lordship.
terms of clause 7.4. He is
Oh.
not indicating the sub clauses.
Lordship.
Now, if you read 7.4.2,
Lordship.
after delivery of the performance notice to the contractor,
Lordship.
right?
Hmm.
The manager shall be entitled to serve 7 days notice as per Annexer Roman 14. Further in writing to either commence the service or improve quality
This is the 7 days notice.
to the prescription. Then next line, the failure to do so shall entail a termination notice,
Lordship.
right?
Being served.
Being served under the hand of the manager to rescind the contract as a whole or in part, as may be specified in such notice, as may be specified.
Lordship.
Then 7.4.3, if no action commences
Service.
to
Or-
commence the service or improve
improve-
the quality thereof is taken by the contractor within the 7 days notice period, then the final
Termination.
notice as Annexer so and so shall be issued.
This is reference to Lordship 7.4.2, 7 days notice, Lordship, as per my understanding.
4 notices.
Lordship.
If I read, one is not, there is no standard format, but as may be specified in such notice. Now,
Notice
if
the
you
termin-
go to the principle of blacklisting, then specific
Notice.
unambiguous notice has to be issued.
Notice.
Due interest has to be passed. Then an opportunity of hearing should be given. Right, that
Right.
you are going to be blacklisted,
Blacklisted.
which will be having serious
Lordship.
consequences. Where is that?
That was not there, Lord. I have to take instruction on that, Lordship, whether this was.
Department aspect, they are totally silent.
Lordship, kindly come to page 136. This is after termination notice, Lordship.
Hmm.
Here it is the last paragraph, Lordship, 136, last paragraph. It is after the termination notice. In response, you have submitted a reply dated so-and-so stating that the station premises were being maintained satisfactory. However, a surprise inspection conducted on so-and-so by the undersigned revealed several deficiencies and the overall performance was assessed as unsatisfactory.
These are post.
Lordship. Accordingly, a 7 days notice was issued to you under clause so-and-so, directing to you make the good default. Despite the opportunity, a joint inspection was conducted on 2012-25 by the railway official, again found the service to be unsatisfactory.
What is the personal hearing opportunity of explaining that you are going to be debarred
from participating
and
That-
blacklisted?
That was, I have to take instruction whether this was there or not.
Because staying a
Because as-
blacklisting order is also serious.
And second.
You
when
have the
reply-
prescribed format or not?
My lord, I have the soft copy.
Huh?
I have the soft copy.
You place it tomorrow.
My lord.
You take instruction.
Lordship in the meeting.
Meaning that if I stay, he will operate.
Lordship. Already terminated, Lordship.
But if it is wrong,
My
you
lord.
find out
Already
whether
New
any
procedure is not.
Lordship, already new
opportunity-
bidding process is also noticed and invited on.
maybe, but otherwise here the right,
Lordship.
inherent right.
Lordship.
If we go by, say, for example, Gorkha security.
Lordship.
As far as performance is also concerned, they said that on
No,
that
we
particular
don't do that.
inspection day, I was
They
back.
may have a right to blacklist you or debar you, but only thing is that we are not into the decision. We are into the decision making
Making
process
process.
only.
Definitely.
That's all. You might have been keeping the railway station dirty. We don't know.
So the record
Right?
says it is.
We don't
clean.
know about that.
Lordship.
If you have done it, then you should be blacklisted. But question is the decision making process, whether that has been complied with, adhered to.
Lordship.
Get the instruction whether anything has been given.
Lordship. My lord.
You place
I'll
the-
place the complete
place the-
copy. I have a soft copy, don't have a hard copy, I will be.
If file it on
Alright.
record. Tomorrow morning you call for the.
My lord, tomorrow. Definitely.
Okay, heard Mr. B. Pathak, petitioner. And Mr. S.S. Roy, learned Central Government Council for the respondent, all the respondents also. As sought for by the learning council, the parties lead the case tomorrow. Thank you.
Item number 13.
Lordship, the matter pertains to non-payment of bills, Lordship. There is annexure 1 is a work order and annexure 2 is.
Any admission of liability?
No, my lord.
No.
No.
We keep it open. We keep it open. Maintainably, we'll keep it open. Hired Mr. B.K. Sharma, learned counsel for the petitioner. And Mr. S.P. Chaudhary, you appear as
For 4 and 5, Lordship.
what day? Urban water.
Urban, yes. What is it?
And who is for
Government.
government? S.R. Borua. Learned Junior Government Advocate Assam for the respondent number 1 and 3. Mr. S.P. Chaudhary, Land Standing Council, Assam Urban Water Supply and Sewerage Board for the respondent number 4 and 5.
4 and 5.
Post of the petitioner has stated that one work order or many? One work order.
No, 2, my lord. Annexure 1 and 2, my lord.
Okay. He was entrusted with, he was issued 2 supply orders.
Yes, my lord.
Supply orders.
For chemicals, my lord.
Supply orders of
21.
a number of chemicals. Within bracket annexure 1 and 2. By the respondent
5.
Number 5. And the petitioner had accordingly executed, supplied the materials as ordered. Post of. After completing the supply, the petitioner submitted his bills before the respondent board authorities for an amount of rupees
14,61,516.
As despite approaches and representation from the said bill amount has not been released till date, the petition is before this court by the state petition. Mr. Borua and Mr. Chaudhary have submitted that the petitioner has not annexed any document relating to admissibility of the claim by the head of the department. And as such, the petition is not maintained. Issue notice returnable on so-and-so, as so-and-so has appeared, accepted. No formal notice, extra copies by within 2 working days from today in view of non-annexation of any admissibility of the claim. Non-annexation of document regarding the claim, in terms of by the head of the department, in terms of the full constitution, so the issue of maintainability of the petition is kept open for comment.
Respondent number 5, actually Jorhat division. It is mentioned as Jorhat. Executive Engineer, Jorhat division.
20.
Lordship.
Item 14.
May it please your Lordship. The petitioner agreed not opening his technical bit as well as finance bit. The bid opening date was 7/10/2025. All total there was 30 packages. They have already opened all other packages, just except this instant package.
Mr. S. Hogler and Council for the petitioner heard. Miss
PCA.
PCA Learning Council on behalf of Mr. R.M. Das, Learning Standing Council, Water Resources Department for all the respondents. The respondent number 5A, where is the NIT? By a notice inviting tender, dated 26/8/2025, the respondent number 2 invited bids for 35 number of contract works. Full stop. The petitioner, who is a class 1 category contractor, submitted his bid for the contract work, serial number 28 or 28 or before the last date of bid submission. Full stop. The petitioner has canvassed that the respondent authorities have already opened and finalized the bidding process in respect of all the other contract works notified in the NIT dated so and so, except the contract work wherein the petitioner has submitted his bid. Full stop. In view of non-opening of the bids submitted in respect of the contract work, and the reference, the petition is before this court. Post of Miss so and so, Land Council, appearing for the respondent authorities, has sought for a week's time to obtain instruction as regards the reason for non-opening of the bids in respect of the contract work under reference. List the case on so and so. Para, Mr. Hawk, Land Council, for the petition will supply an extra copy of the receipt with an extra to meet so and so. During the course of the day. Next.
My lord, here in this case, my lord. This case, my lord, the petitioner's technical bid as well as finance bid was open, my lord. There are two packages, my lord. One package, my lord, they have already issued the work order, my lord, but in the instant package, my lord, they have not yet issued, my lord.
Now, where is it, NIT?
NIT, my lord, you will find, my lord, at page 15, my lord.
Page 15.
My lord.
Okay, page 16.
Page 16.
Nolbari, yes.
Yes, sir.
What
Yes, my
happened?
lord, petitioner had offered his bid against the serial number 1, my lord.
1,
Yes, my
okay.
lord. And serial number 2 had already been opened and it has been settled, my lord. LOA had already been issued, my lord. Work order has been. In the instant package, my lord, the technical bid was open, my lord. Subsequently, my lord, finance bid also open, my lord. The petitioner
You passed the technical bid?
Yes, my lord.
You passed?
Yes, my lord. I have annexed all the.
How many bidders left?
There are 3 bidders, my lord.
3 bidders.
Yes,
So
ma'am. Kindly come to
you
page-
are one of you.
Yes, my lord. Kindly come to page 20, my lord.
Page
20, my lord.
20.
I said D.
Okay.
These are technical.
So you were awaiting?
Yes, my
Yes,
lord.
Mr. Go.
Instruction, you will see page 22.
Page?
Page 22.
Page
Same
20.
petitioner, my lord, he approached earlier. And recent order, my lord, that L1, my lord, minus of the, my lord, financial bid was placed before the honorable court. Then honorable court observed, also will see, it is needless to observe that the respondent authority shall be at liberty to finalize the tender in accordance with law. Probably there, my lord, looking into the aspect, my lord. The apprehension of the petitioner that we may cancel it, my lord, during this period. That, my lord, not sustainable as on date.
That is a different
Yes,
case.
if at all it is cancelled,
That will be a different cause of action.
That will be a fresh cause of
That
action.
is separate thing, my lord, but I'm referring, my lord, page 20.
Already there shall be a liberty. That liberty
Yes,
is
my lord.
granted.
Kindly come to page 25, my lord. They have 2 works, my lord. They have already, this work had already been completed, my lord. More than 50% work had already been completed, my lord. So what is the problem with this, my lord, package, my lord? Why they are not finalizing? This is the against package number 2, my lord. Serial number 2, my lord.
This is the petitioner.
No, my lord.
Some
The
Vikas
25,
Sharma.
my lord. Yes, this is separate, my lord.
Vikas Sharma.
Yes, it's
Same NIT, 2 packages were there, my lord.
one package they have already settled, my lord. The work is under process, work is going on, my lord. My lord, they are hanging up at this instant package.
7-1. 1 month.
Yes, ma'am.
What is the right?
My lord, I participated, my lord.
Participate?
Yes, my lord.
What kind of right a bidder has to insist that you open? Bidder has a right
Yes, my
that
lord.
he should be fairly treated.
Yes, my lord. Article 14 also there, my lord.
Don't bring in everywhere bidder Article 14.
My
At
lord.
the drop of a hat, at the drop of a
Yes.
needle, you
My lord,
try Article 14.
why I am saying, my lord?
What is the tender jurisprudence?
Yes, my lord. Here, my lord.
What is the tender jurisprudence in the context of Article 14?
My
What
lord,
kind of bidder has what kind of right? After page 23,
my lord.
what kind of right? That court has a right and issue mandamus that you open it 7 days.
Yes,
It
there
is
should be
already there
at
to
least-
bring it to the logical conclusion.
Yes, my lord. There should be parity, my lord. Here, my lord, one package, my lord, you have already settled the work, more than half, 50% work has already completed. Why you are, my lord, issuing this
Yes,
work?
Mr. Gogoi, taking your instruction.
Yes, sir.
Heard Mr. S. Hawk, learned counsel for the petitioner, and Mr. B. Will, learned advocate. Assam for all the respondents. So, the petitioner has canvassed that by a detailed tender, under detailed notice inviting tender, NIT, dated 17/10/2025. The respondent number 2 invited bids for 2 contract works. Most of the petitioner submitted his bid in respect of the contract work as serial number 1 therein in the NIT. Post of. When how many times you have approached?
My lord, earlier that was, my lord, site visit certificate, my lord.
No, page 17.
My lord.
What
That
is
site visit certificate was not issued, my lord.
okay?
That was issued, my lord. Thereafter technically qualified, my lord.
In the petitioner's technical bid has been accepted along with 2 others. Post of the petitioner earlier approached this court by another writ petition WP number 7441/2025, which was rendered infructuous on 7/1/2026. The grievance of the petitioner is that the other contract work advertised by NIT dated 17/10/2025 has already been awarded successful bidder. Has already been granted the work order, whereas in respect of the contract work, the respondent authorities have not finalized and issued the work order till date. Mr. Gogoi, learned additional thoughtful list the case after 1 week or 10 days.
Friday, madam. Friday.
Friday next week.
Next week, Friday.
Wednesday. In order to obtain necessary instruction in the matter, is the case so and so. Extra copy I got during the course of the day.
Time of like.
My lord, with due apologies, my lord, I beg to mention item number 23, 44 to 47.
23. Yes.
44 to 47, 50 and 51, my lord. Some of my difficulties, my lord, I have to leave the court now, my lord. Let the matter be taken up next week, any other day.
Okay. On the request of Mr. R. Islam, learned 23. Learned counsel for the petitioner lays the case on so and so. it is submitted that I will inform the learned counsel for the other sides accordingly.
Much obliged.
Same expressing difficulty on his part to conduct the cases today. Mr. R. Islam, learned counsel for the petitioner, has sought listing of the cases on another date after a week. So, okay, 44, anybody appearing? 44.
Well, I have already taken.
Okay, he has submitted that.
I've informed.
He has taken consent from the learned counsel for the respondents to make the prayer. List the cases accordingly by you.
Much obliged.
May it please your lordship. Prepared a list of dates.
Who is this for number 4?
Number 4, Simplex Infrastructure Limited. Limited company.
MSME control. Yes, so we have to issue notice at this stage. We have to issue notice at this stage.
Yes, Lordship, without hearing them, Lordship. It will be.
Heard, Mr. Doctor. Dear Doctor, learned counsel for the petition. Mr. Talda, you appear for whom?
5, my lord. Respondent 5, NHID here.
Miss U. Das. Learned additional senior government advocate. For the respondent number 1, 2, and 3. And Mr. R. K. Taludar. Learned standing counsel NHID cell for the respondent number 5. So, agreed by non-disposal of the of case number AS 22 stroke S stroke ASM stroke 00246 by the respondent number 2. The petitioner is before this court by the state petition to notice returnable on Spence. Class 1 to 3. Kaluga 5. Star copy is steps upon respondent number 4 by the post reading para Ms. Das and it's so and so shall obtain instruction as regards the status of the case number so and so, comma, presently stated to be pending before the respondent number 2, comma, to place the same before this court on the returnable.
18.3.
Yes.
Deeply obliged.
Supplementary list, item 52.
Where is Mr. Bora?
My lord, I have filed an additional affidavit, probably affidavit before.
I have forgotten hostel, I forgot.
My lord.
What are the hostels?
Yes, my lord. Para 6, my lord. Para 6, my lord. Para 6, my lord.
Over is the tender bidding document, page 23.
Page 23, original.
Page 23.
That is the original one.
1 year set outsourcing hotel mess diet catering economic cafeteria service. Okay. And where is the work order?
That is, my lord. Okay. No, not. Next, sir, my lord. 122, my lord. Next, sir, 6, my lord. $122, please.
So boys hostel, you were not allowed to
been
operate.
handed over. Plain boys hostel. So I have.
So on 26/12/2025, you were allowed till finalization the new tender process.
Yes, my lord, 6/26/12/2025.
And then
my lord, page 141, my lord. They have all of a sudden they have issued, my lord.
any tender process?
Tender process, my lord. GM portal, my lord. They have very secretly, my lord. Page 126, my lord. They have done it, my lord. But then
GM portal cannot be secretly, perhaps.
No, that has not been their website. I have made a statement. My lord, only my lord, things to know, my lord, who website. But anyway, my lord, and that, my lord, your lordship kindly see that boys hostel and the girls hostel are not included. Anyway, my lord, so far I have accepted my extension. That is, my lord. So I am go by the extension, no problem, my lord. But now, my lord, they have cancelled my extension even in a midway. Just to give, my lord, all my, I don't know why they are giving, my lord, very much importance to, my lord, respondent number 4, my lord, who is neither a tender nor, my lord, he is, my lord, running the hostel number, boys hostel. Now, as usual, now he is going to taking over the girls hostel, which is not in the tender process, my lord. In GM portal.
GM portal, it is not in the tender process.
Your Lordship kindly see. Item page 126, Your Lordship kindly, very
Page-
cleverly, my lord, they have done it after it. Page 126, my lord.
Hmm.
The item category. Serial, my lord,
Hmm.
1, 2, 3, 4. Canteen service. So it is written as a canteen service.
Hmm.
And upper, my lord, only Jorhat Medical College. Your Lordship kindly see. Canteen service of Jorhat Medical College. Now, my lord, by issuing a corrigendum, page 133. Page 133. Now, one bit corrigendum was issued.
Hmm.
Your Lordship kindly see. Serial number 4.
Hmm.
Tender for hostel, mass service, boys hostel, circular building, administrating block, along with cafeteria. So only cafeteria and circular building, boys hostel. That two are, my lord, advertised. Not girls hostel, nor, my lord, main boys hostel.
Huh.
Those are, my lord, allowed to be run by, my lord. That's point number 4, my lord.
Which one?
Already boys, my lord, they are, which are not handed over to me, run by she. Now, my lord, girls hostel also try to take away from me and give it to give, because he has, my lord, all correspondence under what situation I have, my lord, and writing that letter I have stated in my affidavit, my lord. So now that is my grievance, my lord. Even then, my lord, boys and girls hostels are not covered by this in GM. And before issuing, my lord,
So, as on that you are running a girls hostel,
and
PG
cafeteria,
hostel,
yes,
and cafeteria.
cafeteria,
Now cafeteria has been included now in the
yes,
tender.
yes, here cafeteria is included.
Girls hostel and PG hostel is not.
Not.
Yet respond number 4.
4 already, my lord.
Boys
Boys hostel, now, my lord, going to take over my girls hostel, which is not included in the portal, my GM portal. So that is my case.
Yes.
And
my lord, on last occasion, I produced one letter, my lord, and in addition to that, my lord, on 18/6/2025, my lord, the petitioner was issued a letter regarding the poor quality of food service in the girls' hostel. And subsequently, my lord, recently on 22nd January, my lord, the girls filed a complaint that the food quality is very poor, so they cannot eat, my lord. They then requested the principal that they will arrange their dietary articles on their own, my lord, the girls' hostel, the borders of the girls, my lord. And thereafter, my lord, this step has to be initiated, my lord. Girls' hostel has to be excluded, my lord. Because all the girls came and they lost complaint against the petitioner, my lord.
So you have proceeded straight away to cancel the extension.
My lord, extension was actually, my lord, after that, he has also accepted that the letter that I have
Now
produced.
he has explained, he has tried to explain.
Yes.
That this is the situation in which. And is there any plan to give it to the respondent number 4?
No, my lord. That is not there, my lord. My instruction doesn't say so. Because ultimately, although the girls requested that it should be handed over to the person who is running the boys' hostel, but that was not the understanding with the principal. Ultimately, the girls represented before the principal saying that they will arrange their food on their own, my lord. Because for a long time, they have been complaining about the food quality, my lord. And that letter, for one letter, I have
Which
received.
letter you have? By which letter? Page
18th, I have produced, my lord, 18/6/2025. And thereafter, most of the girls came out with a complaint, my lord. That complaint copy also I have produced, my lord. It is a matter of daily food article, my lord. So otherwise, my lord, the authorities did not have to interfere with it, my lord. And it is not like that it will be awarded to someone else. The boarders of the girls' hostel represented before the principal that they will manage on their own, my lord.
Were you served with this letter, 18-6? Because signature of
Nothing, my lord. Yeah, but
18-6?
18
Not
it
a-
has been served, my lord.
Huh?
Not a single letter has been, my lord. Your lordship, kindly I made a statement. God, that is no, if they didn't, then why they have given me extension, my lord? 18.6, my lord. Complete.
Ultimately, it will be revealed that it has been served because on last
No.
occasion, this fact was also suppressed by the petitioner.
No, I am not.
The
suppressing.
letter dated, my lord,
No. The thing is that,
Three
my lord,
to-
your lordship, kindly see, I have
letter
read
dated
this letter.
3 to-
Whether, my lord, they have, before issuing that cancellation, they have heard me or they have given any complaint, all the complaint which was made against me should have been
because
available to you,
there
my lord.
arose a situation like that, my lord, under compelling circumstances,
Right.
they said that let us continue for another 14 days and thereafter we'll
No.
leave.
14 days, my lord, under compelling situation, my lord, that what
Yes,
they
my
are
lord.
doing, my lord. Your
Because-
lordship, kindly,
because
why
of
it was,
the
my lord, communicated through, my
Poor
lord, on
quality
your
of
correspondence
food,
of
my lord. Because of the poor quality of food, my lord. And
Yes,
it,
right, that I know, but
it is not that it will be awarded to someone else, my lord. It is not the case. I have received the instruction from the principal, my lord. The girls are saying that we have the very poor quality of food, so we'll arrange on our own, my lord.
is it that whether that has been served or not? And here you have received anything in reply?
18/6/2025. It is of 18 June 2025,
Ah.
my lord.
Long back.
Yes, my lord, long back. So that the issue was raising from that time, my lord. Ultimately, that 20, the detailed instruction I have not received, but these are I have received telephonically that ultimately 22nd January 2020.
Because otherwise it is a difficult matter to decide because it is a food.
Yes, my lord, that's why I am saying, my lord.
Everything is on food.
Yes,
My
and
lord,
so
your
far as-
lordship, kindly see this. Suppose, my lord, even despite of that, they are giving me extension, my lord. Not a single line they have written them, my lord. There is not a single
And
complaint against
your-
me, my lord, till today.
If such complaints are received, why not you have put him on
Yes.
notice? That this
Yeah,
is the
but they
way,
should have
so we are
managed
going to
to take back.
terminate you.
No, that is
Because,
admitted
my lord, it is the letter from him, my lord, 3/2/2026, my lord.
after that.
After this issue, my lord, when there was a issue, my lord, then he himself, the petitioner himself said that, give us 15 days time, we will vacate it. 3/2/2026. He accepted
Because
everything.
matter is about food.
Yes, my lord, that's why.
That is a problem, and you have
Your
got
lordship
this
may observe
letter
that
with so much
as,
signature.
as contended by the petitioner that it will be awarded to private respondent number 4, my lord. It cannot be done that your lordship may observe. But otherwise, my lord, with that poor quality of food, the girls are not ready to take it, my lord.
Why that way, Mr. Mohanto, we cannot force it also.
My lord, news story they copped up. Your lordship
my lord.
kindly said there is a admitted position that, my lord, that
22nd one.
all are doing, my lord, mistake is apparent.
No,
Mistake is respondent number 4 is, my lord, he himself, my lord, instigates some 2 or 3 girls, my lord, they are
no, it is about.
No, my lord, I do not know about that. And
No, because
is there any, my lord, communication to me, my lord, that letter?
that is not there, but question
No,
is
they
about 46 girls hostel boarders
Not
My lord.
46.
have
In fact,
submitted if it is correct,
not
22nd
46,
January.
more than 46, because 12 batch 26, 13 batch 50,
So signature campaign is there.
14
ultimately
batch
it is
45, my lord.
If the food quality is not palatable,
Exactly, my lord.
and
Is there any notice issued to me, my lord, that this is the food you will control you?
no, right, but
No, my lord, that's why there is a room for doubt that, my lord, these are concocted, my lord. Your lordship, why I am submitting, your lordship kindly see, while giving extension, now there is no indication, my lord. I am not paying that, my lord. Good quality will be destroyed, and then even then I will be allowed to continue. That is not that, my lord. There is no complaint at all, my lord. And if there is a admitted position that, my lord, that respondent number 4, who is not even a tenderer, how he running the, my lord, boys hostel till today?
That you have waived your right.
No, I'm waived your, but.
By,
Now he's the
by
main man behind this, my lord.
passive acceptance, the boys hostel is not the issue here.
My lord. No,
That
boys
by
hostel not
your
there,
own conduct.
but
here is a case
no, my
of
conduct is nowhere.
50, 60 girls border. They are saying that the food condition is very bad.
No, my lord, this there, my lord, on a basis of that complaint, did they communicated to me or any instruction they have given to me that you food quality should improve?
Otherwise, you are on extension.
My lord, I am in extension. I agree, my lord. I am in extension. Even cafeteria is still, my lord, I am doing. Only the girls hostel, my lord, this type of, my lord, error, but your lordship kindly see the way they have behaved me, my lord.
Around 170 girl boarders, my lord.
No, signatures are there. Let him put on record. Otherwise, you continue with the cafeteria.
Yes, ma'am.
Cafeteria and girls hostel so both, my lord, because your lordship
No,
kindly.
we have to see.
No,
It is
my
not a
lord,
matter of.
no, if your lordship, I do agree to your lordship.
Mr. Mohanta, just that by way of mandamus, if we ask the petitioner to continue, this is a matter. It is not that pencil or pen or
My lord.
computer supply.
My lord.
It is a case of food, and food is consumed since morning to night.
No, my lord.
If about 150, 60, they have said 150, 60 signatures are there of the guards border, how can we
no, my lord,
ignore it?
That is your lordship kindly. If it is in the month of June, then at the time of even cancellation of that, they are not.
No, we are not into that.
my lord,
22nd January 2026.
My lord.
We are into 2000.
No, my lord, that your lordship kindly say now they come with that. If after getting that complaint, did they give any notice to us, my
That
lord?
is because this is an extension period.
Absolutely correct. I
Not
am in
that
extension period.
you have a binding contract.
My lord.
It is at the discretion of the authority to extend. Now, so far as you are running the cafeteria and the process is not concluded, so far as that, till that it is okay. But so far as 170 signatures, we cannot ignore that.
No, I do
Rightly
agree with
or
your
wrongly,
but is it not
on extension more particularly.
Is it not a their duty that complaint,
Absolutely,
my lord?
absolutely.
But nobody, not a single daddy.
It is not that the public interest is also to be looked into.
My lord, correct,
It is
absolutely.
170 girls poster saying that this food supplied by petitioner is not palatable. If that is so, then it is very difficult for court to ignore it.
Correct, absolutely.
Understand the court's position also.
No, if
Cafeteria you are running, you run. So
Correct.
far there
Your
is no
lordship,
complaint.
what?
And so far as this, you should be
But
put
that
on
was
notice.
not even communicated to me.
Now,
I don't know, my lord. Even my lord, they can, my lord, give a notice to
no,
me that
we
it
are
is
on the interim prayer. So far as cafeteria is concerned, no issue. But so far as girls, we cannot let him brought in on record.
Yes, my lord.
This complaint.
Yes.
But in this period, who will run, my lord? In this period, who will run, my lord? Because it is point number 4. The whole trouble is not
Mr.
by the,
Mohanta, you don't have any right.
I don't have
You are
right.
on extension. Your period of contract is over so far as.
My lord.
Right. That is,
But there is a
whose
scope.
discretion is this?
Correct,
It is the
absolutely.
discretion of the authority.
Absolutely correct.
So far as. So the situation which has emerged is that you are still running the cafeteria.
My lord.
Right. And that is.
Cafeteria and girls both.
No.
What?
You are still running.
My lord.
Both. But so far as girls hostel, that is different. But keeping aside, cafeteria, it has been a newly tendered, but not yet finalized. Right. So far as that, you continue to run. So far as girls hostel, let him put on affidavit because it is very difficult for court to ignore it.
Till then, till filing their affidavit, my lord, I may be allowed to continue and give me the, my lord, that I do improve if anything, my lord, complain. No, my lord, I'm just.
I'm not reaching any privacy satisfaction for that.
Then, my lord, your lordship kindly see, even my lord.
Observe so that you can have option.
Because whole things, my probably just 1 number 4, my lord. Because he is now, my lord, even he tried to take over my employees and my employees are going to running. I stated in my. In my.
Sir, is a senior assisted by Mr. And Mr. Deep standing up. Health and Family Welfare Department, was the respondent number 1 mentioned. Full stop. The petitioner was pursuant to a tender process initiated by an IFB dated 19/9/2024 to 2-bit systems. The petitioner, after having emerged as a successful bidder, was awarded a contract for outsourcing of hostel mess, diet, catering, along with cafeteria service at Gauhati Medical College and Hospital, Gauhati, on 9/12/2020, is one poster. According to the petitioner, the tender process was initiated for extending catering services to one boys hostel, one girls hostel, one busy boys hostel, right? And one cafeteria. Full stop. It is the case of the petitioner that despite being awarded the contract of catering services for all the 4 at all the 4 places, within bracket, hostels plus cafeteria. The respondent authorities did not hand over the boys' hostel mess to the petitioner to offer catering services. In that connection, the petitioner submitted a representation before the respondent number 3. Full stop. But the respondent number 3 did not give any consideration to the said representation. Full stop. The petitioner represented again on 6/12/2025. Full stop. The period of contract was from 1/1/2025 to 31/12/2025. Full stop. In the meantime, before the expiry of the contract period, the respondent number 3 allowed the petitioner to continue the catering services at the permitted places by an extension notice dated 26/12/2025 till finalization of the new tender process. Full stop. By a tender notice, by a tender notice floated in the DEM on 5/11/2024. Sorry. 1/1/2026. Where is the new tender?
Page, my lord, 126.
which were invited for page 126.
Corrigendum 133.
Item category, canteen service, last what he say house person. For a period of 2 years. First of subsequently, a corrigendum was issued to include hostel mess service within bracket boys hostel, circular building, admin block bracket close, along with cafeteria service at JMCH. Full stop. According to the petitioner, the tender notice dated 1/1/2026 was not available in the portal. Full stop. Similar is the case of the corrigendum. Full stop. He has submitted, the petitioner has canvassed that by the corrigendum, the cafeteria service has also been brought within the purview of the tender process initiated on 1/1/2026. Full stop. The petition has contended that as on date, the tender process initiated on 1/1/2026 has not been finalized, and the petitioner is still running the cafeteria service at the JMCH.
And culture.
However, as well as in the girls' hostel and the PG hostel. PG hostel you are running?
I am running, no, your lordship don't go by PG, now your lordship kindly see main hostel and boys hostel and boys hostel in round building, circular building. So boys hostel, circular building.
Because your petition is structured in that way, so your complaints are on that way.
Complaints, my lord, your lordship kindly.
No, your representations.
My lord.
You indicated as boys hostel, girls hostel, PG boys hostel. I have gone by it.
My lord, actually, my lord, para 6 is the correct position. Para 6 is the correct position. Para 6. Page 8, my lord.
Okay. অলপ চেঞ্জ কৰি দিব ইয়াতে একদম ওপৰত যে বইজ পেৰাত 6 বইজ হোষ্টেল মেইন গাৰ্লছ হোষ্টেল second boys hostel at circular building administrative block. তাৰপিছত cafeteria service ঠিকে থাকিব.
Now, my lord, in the corrigendum.
You are running boys hostel circular building as on date? Cafeteria, boys hostel, girls hostel.
My lord. Except.
And the other boys hostel, with that man.
By respondent.
The other man.
But in the my lord, corrigendum, my lord, now they advertise only for my lord. Yeah, excluding girls hostel and main boys.
Suddenly, when the petitioner was extending catering services on extension, the respondent had suddenly, on 2/2/2026, cancelled the extension notice insofar as the girls' hostel mess services is concerned. The petitioner has alleged that the cancellation of the extension notice in respect of the girls' hostel mess services is without any prior opportunity and hence arbitrary. Full stop. Mr. Bora, learned counsel appearing for the respondent number 123 has submitted that the petitioner during the period, contract period of the contract period from 1/1/2000 so to 31/12/2025. The petitioner was operating the catering services at the aforestated 4 places. First of, however, during the period, complaints were received from the boarders of the girls' hostel. First of, subsequently, on 22/1/2026, another complaint was received from a large number of boarders. From how many? More than 100.
My lord,
More than 100 number of boarders.
more than 150, my lord.
150 number of boarders of the girls' hostel complaining about the quality of catering services extended by the petitioner. First of, it was in such scenario, the extension notice in respect of the girls' hostel has been cancelled on 2/2/2026.
Page 141.
As he has fairly submitted that as the new tender process initiated on 1/1/2026 has not been finalized till date, the petitioner has been allowed to extend catering services in the cafeteria and the original question, no? In the boys hostel at circular building administrative block, and no decision has been taken as on date to cancel the catering services at the said 2 places. Not returnable. Mr. Bora has submitted that during the contract period, the complaints received from the boarders of the girls' hostel were duly brought to the notice of the petition. First up, though the complaint was not complaint dated 22/1/2026, could not be brought to the notice of the petitioner, but considering the fact that the catering services include what are the diets?
My lord, breakfast, lunch, dinner.
Where is that?
My lord. Somewhere it is.
Page 120.
Includes diets right from breakfast to dinner.
Yes.
My lord, but
Right from breakfast to dinner.
Dinner.
The measure of cancellation, the decision to cancel the catering service was taken, had to be taken as the complaint is regard to poor quality of services. So there are issue notice returnable. As Mr. Bora steps up and
so for is that
the petition has further alleged that in respect of the boys' hostel, main boys' hostel, the respondent authorities have illegally allowed the respondent number 4 to extend catering services therein, though he was not a tenderer in any tender process, right? Issue notice. Mr. Mohanto has further contended that by cancellation of the catering services of girls hostel, the respondent authorities are intending to hand over the said catering services to the respondent number 4. Right?
My lord,
All
that is my,
conditions
my lord,
included?
that is my contention.
Okay. Para. So the catering services, the petitioner's contract period was up to 31/12/2020. First of on 26/12/2025, the petitioner was allowed extend catering services at the at the three places where he was running the catering already operating. Full stop. The fact that though the petitioner was not put on notice before the order of cancellation dated 2/2/2026 by bringing to his notice the complaint dated 22/01/2026, the fact that more than 150 boarders of the girls' hostel had complained about poor quality of food cannot be ignored, as the catering services include diets right from breakfast to dinner. In such view of the matter, this court is not inclined to pass any interim order in respect of the cancellation order dated 2/2026. However, it is stated as the petitioner has stated that he is still running the catering service at cafeteria
Boys hostel round
and main boys hostel in
boys hostel in circular building.
Boys hostel in circular building, administrative block, and the cafeteria. The petitioner, the respondent authorities shall not take any coercive action against the petitioner in so far as as the said two places concerned till finalization of the tender process initiated by tender notice dated 1/1/2026 or till the returnable date, whichever is earlier.
Yes.
Tender process, you did not participate?
My lord, I did not even know, my lord. So hurriedly, my lord, I did not even know, my lord.
Have you contended?
Yes, my lord. I have stated, my lord. I have stated. And in fact, very interestingly, my lord, the main boys hostel and girls now girls hostel
Till the
not included in
the
the
returnable date. Till the returnable date. Till the returnable date. First of the respondent authorities shall bring their stand on record by filing counter affidavit.
Because I have
on
made a
or before
statement.
the returnable.
Yes.
20.
So you continue with two places.
My lord.
Food we cannot ignore.
No, my lord, correct, my lord, but their intention.
Pencil, pen, okay.
Their intention is to, my lord, boys hostel and girls
Pencil,
hostel.
pen, dress, all these are okay. But food, 150 border.
53.
We see, yes.
The petitioner.
Yes, Mr. Bora.
Yes. Petitioner was
NIT. Where is the NIT?
Yes, Lordship. Page 25, Lordship. Page 19, Lordship.
Page
NIT.
19.
NIT. I participated.
Handling and transport contract.
I participated, Lordship. Thereafter, my bid was technically rejected on the ground that the award letter was not given.
Let us see the bid rejection minutes.
Yes, Lordship. At page 125.
125.
The Lordship, 125,
Huh.
25, 11, 12, 16, 15, other details indicated, technically disqualified, Lordship, comments, Lordship gets it. The bidder has not submitted the award letter of the contract as per Appendix 6 of the MTF, model tender form.
MTF means model
Tender form.
tender form.
Model tender form.
Let us go to that
Lordship, now I
appendix 6.
6. Yes, Lordship. 85, Lordship, page 85. This is the appendix 6. What is to be done? We have to upload the documents in the GAM portal, respondent number 5's portal. Now I have done that.
You have done this.
I have done this.
85.
85. I have done this. I have uploaded. Now, whether I am uploaded or not, Lordship, respondent 5 would clearly indicate. Lordship, now I have pleaded that I have done it. Now, what is I have done on 12/11/2025, when I was technically disqualified, I gave a representation immediately as per the NIT. I'll show the clause. Lordship, at page 126, I gave the representation. Now, once I give the representation at page 56 of the NIT, page 56, what you would see at page 56, clause number 18. Immediately, in 2 days, I have given it, 14/11. A laws governing the contract and dispute resolution. See, Lordship. May I read? The results of technical evaluation will be uploaded on a GM portal. In case there are technically disqualified bidders, the reasons for disqualifications will be uploaded and price bid shall be open only after 2 days. If any of the bidders are disqualified, he may submit grievance to the GMR region only through GM portal within 2 working days from the date of disqualification. However, no new documents will be accepted. In case of receipt of grievance, the GMR will redress the grievance by passing speaking order within 7 days after which price bid will be opened. Now, this part they have not done. They did not.
Whether representation was disposed of?
No, Lordship.
Huh?
No, Lordship. I have at page 126, I have given the representation to GMR. It is not disposed of. That is one, Lordship. Now, since it was not disposed of, and the bid validity was for 75 days. I'll show the bid document at page 103. It is for seven.
No, according to you, this representation was not disposed.
No, not disposed of by a speaking order.
Let us see the region of.
At page 125, reason is given. The bidder has not submitted the award letter of the contract as per Appendix 6.
Now, where is the main part of Appendix 6 in the tender document?
Lordship.
Main part of the Appendix 6.
Lordship, page 85 that I have shown, Lordship.
It is related to which tender condition?
Yes, page 21.
Yes, 20.
Page 20. Page 21. Tenders should have experience obtained from manufacturers / PSU, government department, public limited company, private limited company, dealing in the field of fertilizers, food grains, etc.
So, according to you, first
That I have given.
First clause, you said about the dispute resolution that whenever a technically disqualified bidder submits a grievance within 2 days, then that is to be disposed of, right, by passing a speaking order within 7 days, after which the price bid should be open.
Open.
Right?
Open.
So, as your representation is not disposed of, so there cannot be any price opening.
Price opening?
That is one.
That is one.
Right.
Now what they have done, now the bid document, Lordship will come to the bid document at page 103.
What is 128?
128 is I wanted to show that with similar documents, with similar appendix 6, with the respondent themselves, I have been granted a
I thought that it is, but 128 is FCI letter.
Yeah, yes, Lordship. Is regarding other contract in Nagpur. With the similar documents, I have been granted the 10.
Contract. Okay. What you want to show?
103 bid document.
Which part?
Clause number 1, end date 16/10/2025. Now, Lordship would see column 3, bid offer validity from end date of 75 days. Means from 16/10, the bid is valid till 75 days. This expires on 31st December. As I may be wrong, Lordship, 1 day or 30 December or 31st. Now, Lordship would come to the bottom of the page. Lordship would see minimum number of bid required to disable automatic bid extension 2. So there would be no automatic bid extension. So it has to be extended by consent of bidders. I'll show the page. Now, next 104, number of days for which bid would be auto extended is 7, auto extension 1. So there would be, if there is less than 2 bidders, it will be auto extended for 7 days for one occasion.
How many bidders at the technical bid evaluation?
Lordship, I don't know. I participated and the person respondent number 6 also participated. There is 2, so no auto extension. Now, Lordship would.
Why? Who is respondent number 6?
My Lord, I am appearing. Who have been granted.
You said that the price bid has not been opened.
No, price bid has been opened now, Lordship, after filing. On 5th, I filed it. Hurriedly after 5th, on a Sunday on 7th, they have given the work order. Now, my another contention is that the bid has been accepted on 15 January. Now, work order is given on 7 February. That's beyond the bid validity period. That also cannot be done.
Okay. Let us hear.
Yes, my lord. I'm appearing for the FTA respondent, my lord.
1 minute.
Third point, I filed the case on 5th. I served a copy to the respondent corporation. What was the requirement to so a hurried requirement to give the work order on 7th?
You cannot edit. That you cannot edit.
I am just pointing it out.
If you file one petition, another one file one petition, if goes on filing, that does not mean that authority is not.
Yes, Lordship, that is my
authority is restrained to pass the final order. Oh, they can do. Unless they stay. That third point, we don't find any merit.
Yes.
If that is so, by that way, suppose APSC exam, you file it before 5 days.
Yes.
APSC will not declare the results.
Yes.
Huh?
My lord, may I
That is
submit
public
it?
interest.
My lord, the petitioner bid was rejected on 12/11/2025 because of non-submission of the on the ground of the non-submission of award letter as per the appendix 6 of the MTF, my lord. So on rejection, on his technical rejection, he has filed a representation on 14/11/2025, and the GM has disposed of the representation within 7 days, and it has been uploaded in the GEM portal also, my lord. That date I am not now with me, my lord. Thereafter, what happened, my lord? We have opened the price bid, my lord. There were 2 bidders, one the petitioner and one the respondent number 6. So after his disqualification, we have opened the price bid, my lord. Price bid was evaluated, and after evaluation of the price bid, we have issued the letter of acceptance on 15/1/2026. It is not that we have done hurriedly, my lord. 15/1, my junior will submit it before your lordship. Letter dated 15/1/2026, my lord. Asking the other contractor, my lord, to submit the security deposit amounting to rupees 52,95,000 and the BG of 1 crore 5 lakh 90,000, my lord. That after, my lord, the submission of the issuance of the letter of acceptance, my lord, the respondent number 6 has submitted the 50% of the security deposit deposited 26,47,500, my lord, and also deposited the BG amounting to rupees 1 crore 5 lakhs 90,000, my lord. So thereafter, we have issued the work order, that is appointment order 7/2/2026, my lord. Herein, my lord, if any right has been infringed, my lord, the petitioner ought to have come at the right moment, my lord. He was sitting tight from 14/11/2025 when he is alleging that his representation was not considered, my lord. He filed this present writ petition only on 5/2, my lord. Letter of his acceptance was issued in 15/1/2026. We are
Yes.
so, my lord, may kindly have a look at the 15/1/2026, my lord,
Whether
letter.
he can look into his that disposal of his grievance.
It will be available in the JAM portal, my lord. After maybe after the technical disqualification, he may not have access, my lord. We will file the affidavit, my lord. Because in the JAM portal only the bidders can access to the JAM portal, my lord. So after it might so happen that after his disqualification, he might not have any access to the JAM portal.
There is another contention from the bid document. He is making submission that bid offer validity is 75 days. Then auto extension is up to.
If that be so that it has been extended, GM has the power by 30 days to extend it, my lord. We will file a detailed affidavit, my lord.
Where is that? Anything is there in the GM? The competent authority has power to extend it.
My lord, he
Where
has
is
the
the bid
power
validity clause?
Lordship, may I point
Bid
out?
validity clause. Just I am asking him. Where is the bid validity clause in the tender document?
My lord, I'm just looking.
10. That I have seen. From there, I am asking him. From 103, I am only asking him. And this is a detailed bid document, right?
Yes.
You have annexed.
Yes.
No, it is there, my
Is
lord.
it not?
75 days.
Where is the bid validity clause? Page
29. Lordship.
29.
Clause 11. Clause 10 and clause 11.
11 is there.
Yes, 11.
11 is there.
No, Lordship, I'll read it out. The General Manager, Food Corporation of India may extend the bid validity by another 30 days with mutual consent of FCI and bidder. That is by consent. That is not exercised. That power is not exercised.
Mr. Pora, where is your performer? That
And moreover,
where is your extension certificate? Where is your extent that annexer 6?
yes,
You have stated that
yes,
you have
Lordship,
uploaded.
85, page 85 and documents I have to upload in the GM portal.
This is the document you have uploaded.
No, Lordship, they are a separate document.
Now, this is the prescribed appendix 6.
This is the prescribed.
That is on this ground, they have only rejected you.
Yes.
Is it not?
Yes, my lord. Yes, my lord. He has not submitted it.
Something has come to my notice. Let them file affidavit. Shall I indicate to you?
Yes, Lordship.
Huh?
Yes,
Shall I?
Yes.
Okay. Come to page 85.
Yes, Lordship.
This is your experience certificate.
Yes, Lordship.
Right?
Not experience. This is the
No,
form.
this is the ground.
Form only.
No, this is the ground. Where is 10 rejection?
Rejection is 125.
Read. Technically disqualified. Bidder has not submitted the award letter of the contract as per Appendix 6 of the MTF,
Yes.
right?
Yes.
Let us assume you have uploaded it, accepted as per your claim. 85.
Yes.
Name of the client, customer, that is somebody.
Manufacturer.
Name of the contract, contract period, product, total value of the work. Now, next, financial year-wise breakup of the work contract performed.
Yes.
Financial year.
Yes.
What is written there?
25, 26.
Come to page 21.
21.
Read the note.
Let's experience details.
Note. You read yourself.
Experience detail in the note.
Note.
The year for the purpose of experience will be taken financial year from 1st of April 30 to 31st March.
Next word is important. Next word is important after bracket.
Excluding the financial year in which tender enquiry is floated.
Come to page 19.
Yes.
Date of the tender notice.
25/9/2025.
Come back to 85 again.
Yes.
Year.
25/20.
Come back. That is to be excluded. That is to be excluded.
One.
As per note.
Yes, 25/26.
That year is to be excluded.
But going on, yes, Lordship, that is, Lordship is correct.
Then that means there is no expense.
Lordship, no, Lordship,
that is come to 125, the region, annexure 6.
Page 35, Lordship, page 35 says going contract that is going on will also be considered.
What is mentioned? What is mentioned? This year is to be excluded.
The year for the purpose of experience will be
excluding the financial year in which tender enquiry is floated. So you have no experience.
Lordship, but page 35, Lordship will kindly have a look at page 35. And page 21
power to extend
the experience of running contract should also be considered, Lord. This one
would be considered. Had it been 2024, 2025, this page 85 should have included that. If your contract is from 2024, your experience should have 2024-25, not 2025-26. That is to be excluded.
Yes,
it is clear condition in the tender, and you have given experience for 25-26. That is as far that amounts to nothing, no experience. And this is the very document on which they have technically disqualified you. Right. That is not content. But suddenly it is in bold. That is why it caught my notice.
Yes.
And Mr. We'll keep it in pending. We'll not decide it. Find out fault.
Second
in
point
the
is
filed out fault in the bid of the respondent number 5 or 6.
Yes.
Right.
Yes.
Now your concentration should be on that.
Yes, Lordship, and one more thing, the Lordship, even
And
if
further,
we count 30
and
days,
further that
then
letter
also
of
it is beyond.
Yes.
further letter of acceptance and this appointment letter dated 7/2/2026 is also not on challenge, my lord. In this writ petition, my lord. Now,
7-2.
the
But
respondent number
he
6 has
filed it on
started.
5-2. You supply a copy, miss, to him. He may
Yes,
like
my
to
lord.
challenge by way of something else. Heard, and it may turn out that the private respondent may be an invalid bidder also. Let him try his luck. So far, no interim order.
Yes, Lordship, just one thing, Lordship. Even if we count 30 days from the bid validity period, and then also 722 is beyond that.
But here, the matter of interpretation is to be left to them. At least they have a power of extending it by 30 days.
30 days. 30
Now,
days.
my lord,
you know,
another thing, my lord,
75
plus 30.
30.
75 days, if you have said 31st December, then auto extension.
Auto extension in
That
this
is
case.
there. Auto extension 7 days. Right. 7 January. 7 January. And LOA is on 15 January.
Lordship, just I may point
We
out.
are not interpreting it as on dates.
Yes.
This is the understanding of the author of the document.
Yes, Lordship. Just
Yes,
I
We
may
are not
point
jumping,
out.
but as on date, it is palpably clear from Annexer 6 uploaded by you.
Yes.
Are you pressing for interim order?
No, Lordship, not. Because
I
as
can
it is work order.
make an observation so that you can have a second forum.
No, Lordship.
No.
But,
Okay. Then I'll not observe anything. I'll issue notice.
Yes, yes, my lord.
Right. So that you can have your all doors open. Heard Mr. BP Bora, Learned Counsel for the Petitioner, and Mr. B. Singh, Learned
BK
Standing
Singh.
Counsel FCI, to virtual mode for with Miss
Sarma.
S. Sharma, Learned Counsel for the respondent number 1234. 1234.
Lordship, 4.
FCI respondent.
2 to 4. Full stop. Para. The petitioner has approached this court by the instant writ petition, agreed by disqualification of his technical bid on the ground that the petitioner did not submit the award letter of the contract as per Appendix Roman 6 of the MTF, means
model tender form.
Model tender form within bracket MTF. Full stop. By a tender notice dated 25/9/2025, page 19, which were invited for a contract work, handling and transport, at an estimated value of rupees 7 crore 49 lakh. Full stop. The petitioner, in response to the NIT, the petitioner submitted his bids online and has claimed that he has uploaded all the requisite documents, including the experience certificate in Appendix Roman 6. Full stop. The petitioner has contended that as per the Appendix 6, he had uploaded, the petitioner, he had the requisite experience to qualify in the technical bid stage. Full stop. Para, Mr. Singh, Learned Counsel for the respondent
number
FCI
2 to
authorities
6.
has submitted that, Mr. Bora has submitted that the petitioner submitted a representation before the competent authority as per a clause
56.
page
56.
56 as per clause Roman 18 within bracket C of the bidding document within 2 days from the date of disqualification of his technical bid, and the respondent number 3 was required to redress the grievance of the petitioner by passing a speaking order within 7 days therefrom, and the price bid could be opened thereafter only. To stop. The petitioner's grievance is that his representation is yet to be disposed of, and therefore the price bid could not have been opened. Full stop. Para. Mr. Singh, learned counsel appearing for the respondent FCA authorities, has submitted that the representation submitted by the petitioner has already been disposed of by the respondent number 3 within the stipulated time period by way of a speaking order, and it was thereafter only the price bids were opened. To stop. Upon the opening of the price bid, comma, the respondent number 6 emerged as a successful bidder, and a letter of acceptance was issued to him on 15/1/2026. Full stop. Thereafter, comma, upon compliance of the requisite formalities by the respondent number 6, comma, the respondent number 6 has been appointed as the handling and transport contractor for the contract work in question. Full stop. He has further submitted that the competent authority has the power to extend the bid validity period, and the LOA was issued within the bid validity period. The matter would require further consideration, issue notice returnable on so and so, as Mr. Singh has appeared accepted notice 1, 2, 3, 4. No formal notice, extra copies by tomorrow. The petitioner shall serve a copy of the writ petition along with annexer to the Deputy Solicitor General of India within 2 days for the purpose of service of notice upon the respondent number 2 and 5.
Yes, and
SUI.
Yes, yes. Game.
Two copies. Steps upon respondent number 6 by speed post within 2 hours.
2003.
Lord, my name may be recorded as BK Singh, my lord, not B Singh.
BK.
Obliged, my lord.
For admission, item number 17.
Tender method takes a lot of time.
Yes, Lordship. In this case, Lordship, we have filed our affidavit in opposition. That's senior
A
counsel.
big and bulky one, what is this?
Lordship. Lalat senior counsel has informed me that he will not file a reply, Lordship. So Lordship may fix the matter any other day. We have filed our affidavit and they will not file reply. So
Then on a hearing date?
yes, Lord.
On a hearing date. Khali ki ase dibo, 2021 method. Mr. A. Dasgupta, learned senior counsel, listed by Mr. J.K. Sharma, learned counsel for the petitioner is present. Mr. K. Kolita, learned counsel appearing for respondent number 1 and 2 has submitted that. You're filing an affidavit?
No, already filed, Lord.
An affidavit in reply on behalf of the
Affidavit in opposition, Lordship.
respondents.
Affidavit in opposition, Lordship. We have filed.
Okay. And Mr. K. Kolita, learned counsel for respondent number 1 and 2. Mr. Dasgupta has submitted that the petitioner is not going to file any affidavit in reply to the affidavit in opposition filed by the 1 and 2.
Let the matter be fixed for you. Any data.
Okay. As sought for by the learned counsel for the parties, list the case in the admission column on
16.
16. Tuesday or Thursday? Hearing date would be. On a hearing date.
Hello.
Items 18 and 19.
Yes, Mr. Royshuri, what is in store here?
I am a Rickshaw Welfare Association.
Rickshaw,
Malan, I am Deep Bahan. An impugn order was issued where it was directed to withdraw the battery from the Dibbahan. The government comes because it is not- withdraw the battery that battery from the Dibbahan. Then, my lord, because the impugn order says that it's not safe for the commuters in the rickshaw. Then, my lord, the government comes with an affidavit saying that it is only for the e-rickshaw because the Dibbahans have been given protection by an interim order. So Dibbahan, there are two types of rickshaw. One is e-rickshaw.
E-rickshaw is what?
That was through electric, but not that difference. The e-rickshaws are bigger than, my lord, the Dibbahan.
Okay.
The e-rickshaws require some license under the say, Motor Vehicles Act.
For what
Dibbahan-
purpose it has come today?
For admission, my lord. And, my lord, for 19, he is for the e-rickshaw, I think.
You are Dibbahan, he is e-rickshaw.
E-rickshaw. Dibbahan are with an interim protection.
Okay.
Worship actually conducting counsel, Mr. Air is on leg. So kindly. on this
Who
matter
is
for
on
today.
like?
He's
Who is the
on
conducting counsel?
Air Bhuya,
Yeah, Bhuyan. And who is the main respondent? Transport? GMC.
Bora is there.
Where's Bora? Where is Bora? No Bora. Okay then. Conducting counsel Bhuya is not there. Conducting counsel Bora is not there. Okay. P.K. Roy Chaudhary, learned counsel for the petitioner in 18.
18.
And Mr. R.B. Goswami, learned counsel on behalf of Ms. M.D. Bora, learned standing counsel. Transport Department. Mr. Sharma, you are from whom? And Mr. R. Sharma, learned counsel for the respondent number 8 in 19 are present. Mr.
M. Khan.
M. Khan, learned counsel for the petitioner in 19 has submitted that the conducting counsel has some difficulty. Today, Gustav. On the other hand, the standing counsel GMC is found absent today on call. Gustav, as sought for and agreed to by the learned counsel for the parties, release the cases on. Give me the Monday, I'll see it on Sunday. What is e-rickshaw, what is Dibbahan? 2nd of March. Not 2nd of March. Sorry. 9th of March. The interim order passed in WBC 18 shall continue till next.
Items 20 and 21.
Where is Mr. Gogoi?
Is supposed to.
Gogoi was supposed to. Have you met him?
Okay.
Have you met him earlier?
Met him
Today?
Okay.
Okay, after some time then. Let him come.
Item number 22.
Yes, Mr. Oscar, what is this?
I need some further time. Last occasion, we were asked to obtain the status by way of an additional affidavit regarding the lordship status of the license of petition number 2 and 3. Because already petition number 1 license has been reinstated.
What is they? What are they?
They are deed writers, lordship.
Okay, deed writer. Their
Yes,
license
yes.
have been cancelled.
Their
licenses have been
suspended.
Okay.
So, Honorable, on last.
Any DP was conducted or what?
No.
No.
No DP, no.
Then how long you can?
It is
Same principle might apply.
Lordship?
Same principle. What is this principle there in service law? Authorization, because I don't take service matters.
90 days.
Huh?
Within
So
90
that
days,
same
they have to
principle might apply.
90 days.
Okay, how much time you need?
2 weeks, Lordship.
FL Oscar for the petitioners. And Mr. S.R. Borua. Learned Junior. You were there, Mr. Dotto?
1 and 2.
Okay. S. Dotto, Revenue 1 and 2. S.R. Borua.
3, 4, and 5.
Junior, 3, 4, 5. Mr. Borua has sought further 2 weeks' time to file the additional affidavit in deference to the order dated 12/12/2025. So stop. List the case on after. The respondent shall ensure that its additional affidavit is filed before the next date of list.
Lordship,
You ensure.
Lordship.
Item number 24.
Echo did you list that? 24? 24.
Your Lordship, I'm appearing for the petitioner in item number 24.
You are not from this place.
No, no, my
Ah,
Your Lordship.
you are appearing from where?
Your Lordship, I'm appearing from Delhi. I'm
Okay.
practicing in Delhi only. However,
Okay.
yes, Your Lordship.
Yes, Mr. Goswami.
So this is against an order of the Honorable Ombudsman. No?
Okay. Today not possible, next Tuesday?
Yes, sir.
Tuesday ki baat nahi hai. Ombudsman order.
Yes, Your Lordship. We are challenging the
It has-
Ombudsman
it
order,
has-
Your Lordship.
Yes. Export koribo para jao. Boli hazan. Boli ki baat nahi. Tuesday ki ready? লিখা আছে। এইটো নেকি?
2, 3, 4.
এইখন নেকি? Next Tuesday.
Tuesday.
Please, Your Lordship, please.
Okay.
Please, Your Lordship.
Miss Khatun.
Yes, Your Lordship.
Miss Khatun, for us appear to virtual mode along with
yes.
Mr. Sajal Bhuiya.
Yes, Your Lordship.
Okay. Petitioner. Mr. R. Goswami, learned counsel for the respondent number 2, 3, 4, 5 and 8.
Lordship, I'm
S. Dr. 6. So stop. Applicant. Next Tuesday in the admission column, an endeavor will be made for final for consideration of the repeat.
Please, Your Lordship. Please, Your Lordship.
17-2. Item number 25.
Yes,
Lordship,
Mr.
the
Sharma.
respondents have filed, respondent railway has filed the affidavit.
Okay.
Your Lordship, due to some inadvertence, I could not file my reply. I'll pray for some time on that.
Yes, Mr.
There is an arbitration clause otherwise, my lord.
Since he has a right to reply,
No,
I'm not
no.
going into that arbitration. Let him file the.
No, lord.
Okay, you are having some interim protection.
Yes, Your Lordship.
And what about respondent number 7? Yes.
They have not filed their.
You want to file anything?
We did not, my lord. We have
You-
returned the.
Okay.
Do not invoke.
Mr. Senapati. D. Senapati for the petitioner. H. Gupta.
Lord.
Standing Government Council. For the respondent number 1, 2,
6 months.
6.
My lord.
Are present. Mr. M. Smith, Learned Counsel, has submitted that he has entered appearance on behalf of the respondent number 7. So, as such, the service of notice upon the respondent number 7 is complete. Mr. Smith has further submitted that there is no necessity on the part of the respondent number 7 to file any counter. Mr. Senapati has sought for and is granted 2 weeks. 2 weeks. 2 weeks time to file an affidavit in reply to the affidavit in opposition filed on behalf of the respondent of 1 to 6. Stop. Lays the case on. The interim order passed earlier. Shall continue till the next. I say number 2, 23 to be. Yes.
Yeah, Your Lordship, petitioner.
Notice was issued solely here.
Your Lordship. Under
Yes.
this TB allegation.
Yes, solely here. Mr. B. Gogoi.
Your Lordship.
Health.
Personal difficulty, my lord, he is not present.
Okay.
Actually, Your Lordship.
You stand proxy?
Yes.
You stand proxy for him?
Well, here,
Not difficult, only contract dues.
Yes, sir. Here, my lord, my instruction is awaited. I have checked the record, my lord, our record. We have communicated with the authorities. After 2 weeks, my lord.
Mira, for the petitioner, Mr. B. Gogoi, and standing up. Health Department has submitted that instructions are awaited as regards the claim of the petitioner regarding pending contractual use and has sought for further 2 weeks' time to obtain the necessary. The praise allowed, list the case on friends.
Please.
Date I have given, huh?
Pendency manner, already petitioner
No,
has.
they are doing the needful, my lord.
Let
They
them,
have sought for some document from the petitioner, he has
And he
already
has
furnished it.
already furnished.
after 2 weeks, I have given the
Yes,
date.
yes.
9-3.
Mr. Gogoi, you
Time
were
please.
awaited earlier by Mr. Sharma.
But the authorities have agreed that, my lord, if he wants
20
to
and 21.
complete the leftover balance work in the old rate, my lord, that he has quoted at the time of tender, we won't have any objections. But, my lord, let him submit some affidavit on undertaking before the honorable court. Tomorrow again, my lord, it will be a problem.
Okay.
He may submit that.
Or we put it in the mediation.
No, let it be, my lord, here only, because that order is reflected, my lord, in the
Okay,
last
I have
order.
also to,
And I have got the instruction.
Mr. P. Sharma, learned counsel for the petitioner, has reiterated his submission, made on 19/12/2025, that the petitioner is willing to carry out the remaining work at the old rate at which the petitioner was allotted the contract, subject to clearance of the pending RA bills by the respondents. Right? And stop. He has sought 1 week.
Change the statement. My lord will see my instruction, my lord. Our, my lord, only intention is that, my lord, he will have to give an unconditional undertaking, my lord.
What about RA bills?
Yes, that's why, my lord.
There is a rider.
Yes. RA bills, my lord,
Let him come back with the instruction.
Yes.
Right?
Let it be after 1 week, my lord. The work is pending for a long time.
Mr. P. Gogoi, Learned Standing Counsel, PW, has submitted, he has received instruction with regard to the above submission made on behalf of the petitioner from the Chief Engineer PW within bracket H&E Department by an office letter dated 11/2026. Placing a copy of the same within bracket marked and kept as document A. He has submitted that department has no objection if the petitioner agrees to give unconditional undertaking before the court that he will execute the work at the original BOQ rates and the original tender agreement. And if the letter part is not required as on date.
Yes, sir.
So that right is always there for you.
Yes, ma'am.
But, Mr. Sharma, in response, Mr. Sharma has submitted that he will obtain instructions with regard to the proposal from the end of the department within a week from today.
Madam.
List the case on.
Lordship will give a date 2014 contract, madam.
I'm giving.
20. Madam.
Item number 31.
Lordship, may I read the last
Let me read.
Today we have received the instruction. Today we have received the
Positive or negative?
Lordship, as per instructions, the original bills or vouchers are not available in the commissioner. But Lordship, we have already communicated with the Chief Executive Officer Kasar Jilla Parishad to submit the original copy of bills non-real certificate and photocopy of the certified issue by the CAPOL to the successful candidate. Upon completing the
Final opportunity. Second round. Then what is the need? What is the first round? This lack of documents, all these are old thing. Huh?
But
Let us see the first round.
Yes, page 84, Lordship. Start from page 84. Lordship, the first round itself, the respondent authorities, they have found our claim justified, Lordship.
Justified to what extent it is not there, but
And
there
Lordship,
there is some record that perhaps you had extended some training. So your claim is justified.
and Lordship, page 95, they have accepted to the liability to the amount of rupees 8,39,251. And though our claim was, Lordship, 8,45,751. Page 95. His letter was from the Chief Executive Officer, Lordship, to the Commissioner, Lordship. Page 95, Lordship. The last para, Lordship.
Now, what justification you have given in your para-wise comment?
that's the para 10.
So if para 2 is correct,
Correct.
if para 2 is correct, then it is the Chief Executive Officer who is the competent authority?
Because
Huh?
it was, because the training program was under DRDA that time.
Huh? So I am.
And DRDA was
Hmm.
abolished on 2017.
So who takes over the responsibility? Chief Executive
Chief
Officer.
Executive Officer. So for
If
that.
paragraph 2 is correct, paragraph 2,
That's
paragraph 2,
that's
that The subject matter does not fall within the commissionerate,
Lordship.
then chief executive officer is liable.
So for that purpose.
Then he has admitted
Sir,
at page 95.
Lordship, kindly see in our para-wise comments, annexer, order dated 27 March 2020.
27 March,
2025.
at last page.
Lordship, annex. Para-wise. After verify.
If he is not the competent authority,
Lordship.
what
For that purpose,
what
Lordship.
permits him to examine this? Paragraph 2 says that chief executive officer, he is all in all.
Chief
He is all in all.
Lordship, actually, we are the parent department, and that time this program was under DRDA. That, but 2017, the DRDA was abolished.
So, DRD abolished. Thereafter, who is the person?
Then
Chief executive
Chief
officer?
Executive Officer, then
He is admitting a liability.
Lordship.
Huh? And paragraph 2, you said, commissioner says, no, I don't have any business with it.
Lordship.
Huh?
So for that purpose, we have already sent a letter to the Chief Executive Officer.
For what purpose? You say that it is completely within the jurisdiction of DRDA.
DRDA.
Now, DRDA was project director DRDA.
DRDA.
After abolition, it is a chief executive officer. He is the all in all.
Lordship.
And you said commissioner,
No any role.
no any role.
No any.
Then why you are calling for those contradictory stand?
Lordship,
Paragraph 3. After abolition, who takes over?
Chief Executive.
You represent chief executive officer also?
Lordship.
So,
Lordship, we have already communicated with the chief.
what purpose?
For original bills
It
submitting.
is not our business to look into how he gets the fund.
So Lordship will take instructions from the Chief Executive of. Lordship, kindly see para 8 in our text.
When did you execute the work?
Lordship, in the 99.
99.
Yes, Lordship.
And when was your first litigation?
First litigation in the 2015, Lordship.
Huh?
20.
2018.
2015, Lordship.
15, after 15 years.
Yes, Lord.
What kind of document you have submitted here in your support?
Lordship, bills. And Lordship, this is the 95 is the report as sought by the Lordship Commissioner. And thereafter, the Chief Executive Officer submitted this report, Lordship.
Which one?
This page 95, Lordship. The earlier communication notice, page 94.
The DRDA has been abolished.
Yes, Lord.
Right. Functions are taken over by project, CEO,
Executive officer now.
Jila Parishad. But at the same time, there was no fund under DRDA. No fund under DRDA. Whatever you have got 7 days time, if not submitted, then there cannot be any further time to file the affidavit. Don't take any plea.
That's
If by next Friday, the affidavit is not submitted, then there's that the affidavit thereafter shall not be accepted.
that's
Thereafter, we'll think it over what to do. Heard Mr. S. Sutola,
Yes, Lord.
Learned Counsel for the petitioner, and Miss N. Ora, petitioners. Miss N. Bora, Standing Counsel, Panchayat and Rural Development Department for the respondent number. Please tell who are the respondents.
hearing. On the number 1, 3, 4, 5, 7, and 8.
7.
That's it. That's it.
Sir, where is the Chief Executive Officer? He has done a vanishing act.
That's
Lordship, the Chief Executive Officer is the District Commissioner.
Oh.
no, not
Oh.
Lordship, no Lordship.
No. We are dealing with, I have spent 15-20 minutes. DRDA is taken over by whom? Chief Executive Officer Jila Parishad. That is the stand.
Chief Executive.
The main man is not there. Whom to direct? They are saying that commissioner has no business.
Lordship, in that case, I may be allowed
That
to.
I don't know. We are not here in the advisory role. For the respondent number, district commissioner is completely different.
District.
1, 3, 4,
1, 3, 4,
5,
5, 6 also.
6 and
Sense.
8. 8 is not there. He already gone.
Now it's not.
He was not there. 2017. And Mr. S.R. Borua, learned junior government advocate for the respondent number 7, District Commissioner Kachar. So Mr. Borua has submitted that the District Commissioner Kachar does not discharge. Or chairman, he is chairman.
Yeah,
but
dear
not
Chairman.
the
I submitted that both Ms. Bora and Mr. Borua have submitted that the District Rural Development Agency, DRDA, was abolished. Oh, no, stood merged with the Zilla Parishad, with effect from 1/8/2017, and no funds are available under the DRDA under the schemes administered by the erstwhile DRDA. Also, para. Ms. Bora has further submitted that she has received instruction. Para voice comments from the respondent number
Number 1.
3 or 1.
Respondent number 3.
3 to file the counter affidavit and has been chosen for further 1 week time as a last opportunity to file the counter affidavit. Full stop. The request made by Mr. Bora is allowed as a last opportunity. Full stop. Such affidavit shall be filed on or before 20/02/2026. Full stop. It is observed that in the event no such counter affidavit is filed on or before 20/02/2026. Then the same. Then the counter affidavit shall not be accepted for consideration thereafter. Leaves the case on. Second March.
Lordship, 2nd March, I have a fixed matter at Arunachal, Lordship.
6 March.
All like that.
35,
Ms. Bora, last opportunity.
My lord, on the earlier occasion, they were supposed to file the affidavit, my lord, on or before 6/2/2026.
Your Lordship, we are praying for.
The contract entered into. Terminated.
Terminated, my lord, without giving any reasons and without giving any written notice.
Performance guarantee.
We have asked for the performance guarantee, but they have not released it.
Here, this petition is for what?
They impugned
Challenging termination.
termination and also releasing of the PBG.
Yes, Mr. Gupta.
My lord, we'll pray for time to file affidavit, my lord.
How much time you need?
Not a week's time, my lord.
Huh?
10 days.
Because the termination has been done illegally because we have not received the written notice till now.
You appear for which of the respondents? All?
I think all the respondents.
All, madam.
All?
Yes, ma'am.
Okay, Mr. D.R. Dotto.
A.R. Borua.
A.R. Borua. Heard Mr. A.R. Borua, Learned Counsel for petition, and Mr. H. Gupta, Learned Central Government Counsel for all the respondents. Mr. Gupta has sought for and is granted 2 weeks time to file a counter affidavit. Is the case on after two weeks.
11-3.
Can it be in the first week of March?
First week of March, there are 2 holidays, Tuesday and Wednesday.
It will be on 5th of March.
It is not a case to be fixed on.
37.
We can put it on 9th of March. 9th of
9th of March.
9th of March.
May it please your lordship. My lord, in this matter, I need some further time to file my affidavit in opposition.
Okay, Mr.
N. Borua. C. Paul.
C. Paul, petitioner, present. Mr. N. Borua, Learned Standing Counsel, IOCL.
IOC.
How much time?
3 weeks now.
Okay, has sought for and is granted 2 weeks time to file the counter affidavit. Full stop. So SR Borua likhi dibo, present bully 1 and 2. List the case on so and so. Interim order?
Yes, sir, interim
The
order.
interim order passed, I shall continue till the next.
Obliged.
Item 38.
Yes, Mr. Das.
2,53,242, my lord. Chief engineer wrote to the executive engineer, and thereafter executive engineer also paid for my lord fund, demand of the fund. This way it is pending. Page 34.
Yes, Mr. Bhuya. Affidavit. No, nothing from chief engineer.
Yes, it has. Page 34.
Page 34.
Yes.
34.
Annex 9.
Examine.
Yeah, next page is also.
Examine by executive engineer.
And executive engineer wrote back to the chief engineer that
He has increased the amount.
not increased, but 2 lakhs.
Come to page 34.
Lordship, 2,53,000.
Okay.
Next page, last page.
Yes, Mr. Bhuya. Who is a PHE?
Lordship.
Okay.
Lordship, I'll inform.
Otherwise, Mr. Das will issue suit and side order.
Lordship.
Yes, Mr. Das? Is it not?
No, this is fun only.
Suit and side.
Item 40.
Thank you, sir. Actually, tender matter. my lord. We have to file
Tender matter.
affidavit.
Enjoying interim order.
Yes,
Yes.
No affidavit.
No, Lordship, we have also already informed the department. Department will be sending us pair-wise as soon as possible.
Okay.
Lordship.
How much time?
Lordship, 2 weeks time.
Okay, Vijay Ghosh, petitioner present. Mr. M. Bhuya,
Lordship.
Learned Counsel on behalf of Mr. B. Gogoi,
Lordship.
Standing Counsel. Nice thing, PW has sought for and is granted 2 weeks time.
Lordship.
3 weeks time to file the counter affidavit. For the respondent, any private respondent?
No, lordship. No, lordship.
For all the state respondents.
Lordship.
Okay. List the case on so and so. Any pending litigation, division means?
Yes, Manli, there is a pending litigation. During the pending litigation, they come up with a fresh tender. When the matter is under session of
Okay.
the.
The interim order passed shall continue
Lordship.
till the next.
Much obliged. Obliged. Item 41.
Yes.
My lords, in this matter, the petitioner challenged the tender process for procurement of vehicles. So my instructions is that at that tender process, since none of the bids that we received were responsive, that will perhaps be cancelled. And in the meantime, we have invited quotations from all the participants, including the petitioner. So it's like a reverse auction. So formal order is yet to be passed. Some time may be granted to us, then perhaps the matter may itself become infraction.
Okay. DK Nath, petitioner present. Mr. KP Pathak, standing as repetition, has submitted that he is awaiting further instruction in the matter and has sought for listing of the case when?
2 weeks time.
Tell me the date.
25th of February.
Okay. 25th of
February.
February. Okay. List the case accordingly answering. So the interim order pass idea shall continue till the next.
Deeply applied.
Supplementary list, item 55.
Hello, may I pay for except 25th? I have to
20,
26,
okay.
26,
27.
27. Obliged.
55.
Lordship, we have sent for vetting for the affidavit in opposition.
We can,
Can-
55.
55. Can it be in a next week? Lordship?
Okay. Send for waiting, then it is quite okay. Mr. A. Deka, petitioner present. S.R. Burwal, junior government advocate, appearing for the official respondent, has submitted that the draft affidavit in opposition has already been sent for waiting, and the same will be filed within 2 weeks' time. 2 weeks?
2 weeks.
2 weeks.
2 weeks.
Okay. The prayer is allowed. List the case on files.
Item 56. Six.
Yes, madam. As per so an amended cost title has been submitted. Respondent number 6. Respondent number 6. Who represents respondent number 888? Mr. Borua, amended cost title. Respondent number 8. Municipal Corporation Dhubri, represented by Commissioner. That will be sent by steps by post. Steps by post, perhaps. No. Municipal board has been. You are appearing for municipal. Good. Wrong again. That has I. Are you sure? You otherwise appear. Huh? You are Asroy.
Yes, Lord.
Huh?
On behalf of S.
You are not Asroy. You are P. Hazarika.
P. Hazarika.
Okay. You have implemented one municipal corporation Dhubri. Right? There is no entity like municipal corporation Dhubri. It is still Dhubri. Municipal board. So since you have implemented this entity by a judicial order, so it cannot be rectified by way of amended cost title. You have to file another IA for that. Have you understood?
Yes, Lord.
So we cannot send notice to a non-entity. Respondent by it. Have you understood?
Yes, Lord.
Miss D. Hazarika, that is counsel for the petitioner. Petitioners. N. Bora. Miss N. Bora. SC. Panchayat and Rural Equity. 1,
And
3, 4,
4.
6. Mr. S.R. Borua. 2 and 7. And Miss
S. Ajmi. I'm for respondent number 5.
Respond number 5. Full stop. 5. An order dated 21/1/2026 passed in an interlocutory application, IAC number 97/2026, the petitioners have implemented an entity named, quote unquote, the municipal corporation, Dhubri. I have to tell you, EOPS so as party responded by it, post of Mr. PC Authorised, PC, PS Authorised, learned counsel who is in the court has submitted that he appears on behalf of Dhubri Municipal Board and there is no entity named municipal corporation. Para. Therefore, he cannot enter appearance on behalf of so-and-so, which is a non-entity. Ms. Hazarika has sought further 2 weeks' time in view of such back situation. The above backdrop, Ms. Hazarika, Land Council, appearing for the petition, has sought 2 weeks' time to obtain to complete her instruction and to file appropriate pleadings if so advised. So, place the case. The prayer is allowed. Place the case on. I said initially, I said by IA they have brought it. Yes. Municipal corporation, which is not existing.
Item 44 orders.
Old.
The employees of a government of Assam undertaking, called as Assam Politics. So this undertaking is not functioning since 2001. They have handed over transferred their share to a private entity. Some of that private entity has also not able to start their functioning. The result, my lord, the petitioners who were working should be considered they have been retrenched, closed down. The last occasion, this honorable passed an order directing the government advocate to take information that
Your Lordship, that instruction is awaited, Lordship.
So you were earlier employees of
Assam Politics Limited. Is the government of Assam undertaking.
Politics Limited.
Limited.
That stopped functioning since
2001.
1. Thereafter, business was transferred to respond number 5.
5.
When?
In the year 2001.
1.
2001.
And whether it operated for some time? No, not at all.
Since 2001, it is not functioning.
And what was the condition for transfer employees with regard to employees?
There was no such conditions as such. Even when an undertaking is transferred to one body to other, the person concerned who are working in the earlier body, they are entitled to have the retrenchment compensation.
Okay.
So at least this retrenchment compensation should be paid to us. Since 2001, it has not been paid. The last occasion when this matter was put was to know whether it is still in existence. Only thing is
Mr.
that they have to pay our retention
Ah.
compensation.
Otherwise, for such kind of activities, who is the department?
Industry department.
Industry. Now there is no standing council industries.
Right now, we are taking care of it.
Okay. Then you take this and plus public enterprises department.
Yes, yes, yes.
Both.
We have already communicated, Lordship.
But when it was communicated?
18/12/25.
Most of these employees
Then-
expired. Most of the employees
And
expired.
then,
Their legal heirs are
you
being replaced.
take instruction
Lordship.
immediately.
It's an unfortunate case.
27/2.
Lordship.
Otherwise, we'll order for appearance of the commissioner through PC.
Lordship.
A. Rajgupta, senior counsel, stated by Mr. Sharma, J.K. Sharma, for a petition, and Mr. S.R. Borua, learned senior government advocate, Sam, for the official respondents. Full stop. Mr. Borua has submitted that though in reference to the order dated 16/12/2025, communication has been made on 18/2/2025. 18/12. No response has been received. Full stop. The instruction sought by this court on 16/12/2025 is that whether the entity impleaded as party respondent number 5 is still a going concern and functioning. Full stop. As the entity, Assam, Messrs. Assam.
Politics.
Messrs. Assam Yarn.
No, that is private. The petitioner they are claiming is that Assam Politics Limited.
Assam Politics Limited.
Was a public sector undertaking.
Yes. Government of Assam.
Was a government of Assam undertaking, it appears that the Industry and Commerce Department and Public Enterprises Department, Government of Assam are the departments who are best positioned to apprise on the aspect. First of released the case on 27/3/2025. First of, it is observed that in the event, no instruction is placed, no information is placed on the next date of listing, the court might consider for appearance of the concerned commissioner and secretary, or commissioner and concerned of the concerned department to appear to VC.
It will also filed by it.
When? Long back, 2015.
Yes.
We are 11 years. List.
2015.
27/2.
Lordship.
This time you inform.
Lordship.
Then otherwise they have to.
43.
May it please your lordship. Your lordship, a writ petition was filed for the non-payment of outstanding bills amounting to rupees 28,16,587. Initially, this amount was also disputed by the respondent authorities, and an affidavit was filed by the respondent authorities where they have admitted their liability of rupees 15 lakhs. The petitioner, going through a financial hardship, accepted this order, accepted this amount, and hence this writ petition was disposed of. And the respondent authorities were directed to clear the payment. But there was inaction on part of the respondent authorities. And looking at the inaction of the respondent authorities and being aggrieved by their behavior, the petitioner filed a contempt petition. Now, at the contempt proceedings, this admitted figure is sought to be diluted on the pretext that the original bills allegedly available with the department reflected a reduced entitlement of rupees 10,78,220. Now, such shifting stance and inconsistent assertions.
Lordship here,
Is it permissible?
Lordship here, we have paid the part, the amount which is on record. This is, if we refer to order dated 22/9/2025. Lordship.
What is
Lordship
your
here-
instruction beyond
Lordship here, they have filed an affidavit.
78,220?
Lordship,
What is your instruction regarding payment
Lordship,
for amount beyond 10,78,220?
Lordship here, they have filed an affidavit in reply. Lordship may can grant us 2 weeks time.
Your
Obtain
Lordship,
instruction.
Affidavit of opposition already filed by
Yes, Your Lordship.
additional commissioner.
And they have filed an affidavit in reply, Lordship.
Who are you?
Lordship, here I'm for all the respondents.
All the respondents. Who has filed affidavit? They have filed an affidavit, right?
yes, Your Lordship.
Lordship, they have filed an affidavit in reply.
In the,
Respondent number 2.
yes, Your Lordship. Sorry, oblige.
Respondent number 2 has already filed an affidavit.
Yes, Your
Lordship.
Lordship.
Ah.
In that affidavit, they have now sorted to
I have
claim.
seen.
Yes, Your Lordship.
I have seen. Now, you correct your mistake or face contempt proceeding.
Lordship may kindly grant us 2 weeks time to obtain instruction.
Otherwise, contempt proceeding is to be drawn up. There is no option. Once you admit, thereafter, writ petition has been disposed of. Thereafter, contempt petition is filed. You reduce the amount.
Lordship here, in order dated,
Mr. Counsel, I saw an incident. There are vendors in Calcutta. Then 2 friends gone there, bargained for a wedding apparel. Vendor said 1,000. Then friend said 600. The vendor readily agreed. Okay, 600. Then the buyer said, oh, he had easily agreed. Let me say less. He again asked, no, not 600, 300. Then within a moment, 100 vendors out them and chased them for 1 kilometer. Right. So, 28 lakh. You said 15 lakh. Then they asked for 15 lakh. Now you said 10 lakh. So it is similar story. Though there was chasing, here is contempt proceeding. Is it not? Similar. Story is similar. So
Lordship.
you asked your client,
Lordship,
tell this story,
Lordship,
right?
Lordship.
And ask them to remedy their mistake or face consequence. Right?
Lordship. Lordship, may-
Court is not otherwise very happy to initiate contempt proceeding. Yes. I have seen anything to be added. The story I have added, anything? So message is gone. If he has understood, message is gone to will be gone to his client. Remedy, take your instruction from your client that they should act according to court direction, or when was the order passed?
Your Lordship, the writ petition order was passed on 16/9/2024.
24, 2 years. Third, Miss
A. Khashnobish.
A.
Khashnobish.
Kasnovic, Learned Counsel for the Appeal. And Mr.
R. Sahana on behalf of Dinat.
R.
Sahana.
Saho
Sahana.
Sahanand.
Yes, sir.
Sahanand,
Lordship. Sahana. I'll write it down, Lordship.
Learned Counsel for. Where is Mr. D. Nas? On behalf of Mr. D. Nas.
Lordship.
Learned Counsel for. How many respondents here?
4 respondents, Lordship.
All the respondents. Close to. It. Ms. Khasnovi's Learned Counsel for the petition has brought to notice that the writ petition was disposed of. With a direction to the respondents to make payment of an amount of rupees 15 lakh on the basis of an admission made in an affidavit filed by the Deputy Commissioner Dhuburi. Commando, the original claim of the petitioner was to the extent of rupees 28 lakh 16,587. So stop. When the amount of rupees, when the direction to make payment of rupees 15 lakh was not complied with, the petitioner in this condemned petitioner petitioner has preferred this contempt petition. First of, in the affidavit in opposition, filed by the respondent number 2, it is mentioned that upon verification, they have found that an amount of rupees 10 lakh 78,220 is only due. And you received it? No.
Yes, I've received.
And the said amount has been sanctioned. Full stop. After admitting liability to the extent of rupees 15 lakh, such is release of an amount of rupees 10 lakh 78,220 appears is suggestive of an act, contemptuous act. Full stop. Para, at this stage, Mr. Swain's Learned Counsel for the petition has paid for 2 weeks' time to obtain further instruction in the matter.
Lordship, if I may say, in the writ petition filed by the DC, it's not admitted in the affidavit. It's a letter forwarded to the concerned department for verification, Lordship.
Your Lordship, based.
Direction, you are undermining the direction of the court. Whatever is there, direction is to pay 15 lakh. And you are playing with fire now.
Lordship, hello.
You don't douse the fire, then you will also. Clear, to pay 15 lakh. Page 13. Let me find out the affidavit. There is no unconditional apology also. He has clearly confronted the court now. Where is the paragraph regarding unconditional apology? Have you learned about the art of drafting in contempt jurisdiction? Mr. Ghosh knows. He was government advocate for so many years. There is no apology, even if I have committed mistake inadvertently. Absolutely nothing. Who is this man? Oh, within 2 weeks. Otherwise, he will be retiring. He will be out of reach. Before that, he should go to someplace else. This is the case.
Filing at this stage.
Trying to find out whether he makes any unconditional apology or not. I have seen the affidavit. There is absolutely nothing regarding that. First principle of drafting is that in a contempt jurisdiction, you seek apology for any mistake committed unknowingly. Thereafter, you contest. But here is nothing. He has straightway contested. So that is what I tried to convey. Whether he has understood or not, that is another matter.
Second verse.
Deeply obliged, Your Lordship.
Item 48.
May I please? Lord, kindly peruse the order dated 19/12/2020. Last order. After admitting, my lord, almost 5 months has left over, my lord. Not, they have not paid, my lord, till date, my lord. 13 lakhs.
No, that is not the issue, Mr.
Yes, ma'am.
First, you should have pointed out that the affidavit is served. This is not for that purpose. Today it has come for report as regards service of notice.
Was directed to the respondent, my lord, contempt, my lord, to file the affidavit before 4th of this month, my lord. I think, my lord, till today, my lord, they have not filed.
Mister, I have already said to you, how much years of practice you have put in?
Sorry, my lord.
How much?
My lord, 10 years.
How much?
10 years.
You personally handed over to him. Is it his signature?
My lord, his official has received this the justice service.
Heard Mr. A. Hussain, learned counsel for a petition. Post of the affidavit as regards service of notice by your dusty has been filed. Post of as per office note dated 9/2/2026, no ID card, no neither ID card nor unserved notice has returned back from the sole respondent. Post of the matter be placed before the Rajima court to ascertain the status of service upon the respondent by respondent sent by speed post. Post of place the case after 2 weeks, we can report of the Lodging.
49.
Continue, পুরো কইলো।
Contract dues or what?
Yes, my lord. So
Contextual.
3 crores 30 lakhs.
But I have also been.
Work was of the health department executed by the PWD. So that proposal has now been sought for by the health department from the chief engineer, my lord, because they are the one who were in the field. So they are working on it, my lord. I pray Lordship will proceed after 4 weeks, my lord. I will place the update again, my lord.
And Mr. Vijay Ghosh, Learned Counsel for the petitioner. Mr. B. Ghosh, Learned Additional Advocate General, who appears for the PWD, Finance and Health and Family Welfare Department, Government of Assam, has submitted on the basis of instruction received from the Director of Health Services Assam, provide an office letter dated 6/2/2026 that the authorities are jointly looking into the aspect of liability and the matter is in progress. First of, he has sought further 3 weeks' time to obtain instructions to let us to place it before the court. The request made by Mr. Gupta is accepted. Please the case on.
Supplementary list, item 59.
51 is Johnny. John. Okay.
Please, your lordship.
1 minute. Miss Bora, you are for? 1, 3, 5, 7. Right? 1, 3, 5, 7.
1, 3, 5, and 6.
Okay. 4, 6, and 8. 2 by Borua. 4, 6, and 8. So complete.
Yes.
Mr. Ahmed. M. Ahmed, Learned Counsel for the petitioner. Ms. N. Bora, Learned Standing Counsel, Panchayat and Rural Development Department for the respondent number 1, 3, 5, and 7. And Mr. S.R. Borua, Learned Junior Government Advocate, Assam for the respondent number 2 are present. As per law, as per order dated 10/2/2026 of the Law Jima Court, service of notice upon the respondent number 4, 6, and 8 is complete. As all the respondents are served with notices, let the case be listed in the admission column on Wednesday.
Any date next week, lordship. This is tender matter, lord. Highly apply.
Oh, Mr. Das. Who is your opponent?
No, they have
Late. Now you have to issue that order. Mr. H. Das, Learned Counsel for the petitioner is present. First of the Learned Counsel for the respondents is Learned Standing Counsel, PHE Department.
PHE.
He is found absent today on call. Full stop. In view of non-representation on behalf of the respondents, let the case, for ends of justice, be listed again on.
In the earlier case, Lordship, interim order was there, Lordship. Item
The interim order
59.
passed earlier shall continue. Check shall continue till the next list. Any case pending?